content list of final disclosure item 1, second April 65 of 2016.
Mr. Kumar Sani is stuck in traffic and the files are
Stuck in the traffic? The appellant would pray for a remand, correct? कहाँ है Mr. Sani?
he is approaching this.
आने दीजिए. पास ओवर है 11 बजे तक 12 बजे तक 12
Item 2, second April 591 of 2017.
Yes, appellant. You have given a list of judgments total 19 in number. The judgments which you will not place, we will not record. आपको judgment place करना होगा. Facts के साथ, ratio, everything has to be placed. ऐसे list देने से नहीं होगा.
I will try to do today.
जो आप place करेंगे, वही हम consider करेंगे.
I am not also feeling well. Therefore, जितना हो सकेगा उतना कर
पिछली
पाएंगे.
बार भी इसी ground में आपका time हुआ था.
Time और नहीं मार. लेकिन
पिछली बार आपका किस ground में
नहीं
time हुआ?
इसके बाद तो मैं बाहर गया था आया था.
Abroad गए थे, आपकी तबीयत ठीक
I am
नहीं
not
थी.
saying कि I am not. लेकिन अगर मुझे suppose in the meantime
ऐसा in the meantime थोड़ी होता है. सर्जरी शुरू होने के बाद खत्म ही होता
जितना
है.
होगा हम करें.
नहीं ऐसा नहीं होता. ये either you finish it or you don't have it.
I will try.
ऐसा टाइम पास वाला आर्गुमेंट नहीं चलेगा ना.
pass
सेकेंड
होगा.
अपील.
Yes,
फिर क्या? फिर क्या?
मैं start
You have got all these judgments for yourself.
right now अभी तो.
तो फिर आप कैसे प्लेस करेंगे अपने judgments?
ये हम लाइब्रेरी से सब निकलवा रहे थे.
निकलवा कब देते हैं? जजमेंट के बाद. यस. फिर तैयार हो क्या? इस तरह से नहीं होता है. यहाँ पर ड्राइंग रूम टॉक्स चल रहा है. आज नहीं अब कल फर्दर हियरिंग कल.
नहीं ऐसा नहीं.
फिर क्या? आप इतना बड़ा लिस्ट दिए हैं 19 जजमेंट्स का. नाम लेके आए. बताइए तो किसमें कौन सा रेशियो है? पढ़े भी नहीं. फैक्ट भी नहीं पता हो.
ये फैक्ट तो पता.
बताइए ना कौन से जजमेंट का क्या फैक्ट है. बताइए.
अभी जजमेंट को बाद में डिसाइड करेंगे.
बाद में की बात नहीं है ना. जब इस तरह का लिस्ट आता है तो हमको समझ में आ जाता है कि वकील साहब ने एक भी जजमेंट नहीं पढ़ा. डिसाइड करने की कोशिश करें. You don't have the books for yourself. आपने लिस्ट यहाँ पे दिया है? कोर्ट आपके पास लिस्ट आया है? आपके पास लिस्ट आया है? नहीं आया है. उनके पास भी लिस्ट नहीं है. कल? नेक्स्ट डेट तो कल ही होता है. Essay number 591 of 2017. Counsel for the appellant seeks adjournment. Post tomorrow. (10:30) first case. Next.
Item 3, first April 126 of 2019.
जितना भी list of judgments हैं, submitted. list of judgments. So एक जगह soft copy कर. इसका जजमेंट हम ऑलरेडी लिखा चुके हैं. It stands dismissed. The judgment will be uploaded by tomorrow or maybe day after tomorrow. थोड़ा सा correction होगा. Dismissed.
Item 4, second appeal 245 of 2019.
Great for a short pass over. Senior counsel Mr. Manju Prasad and assistant.
आप बहस करिए ना, आप इतना अच्छा बहस करिए.
And in Lordship, this matter between the same parties, another second appeal has been decided by this honorable court.
Decided. Where is that judgment?
Between the
SA
same
number?
parties, Your Ladyship,
SLR.
arising out of
631
631 of 2015. In that, it was cancellation of same.
2015.
Yes,
And this is 2019.
yes, Your Ladyship.
How? Arising out of the same judgment.
Your Lordship, parties are same. In the judgment that I've just passed to Your Lordship, in that the question was regarding cancellation of registration deed, and they had questioned the power of attorney. In this matter, arising out of the same parties, between the same parties, the same power of attorney, the matter was there, and here we had filed, the respondent had filed an eviction suit against the petitioner
Based
from
on
the same property,
From the same property and on the basis of same power of attorney.
same power.
And that power of attorney has been held to be void.
Here, Your Ladyship, they have alleged that we had not annexed the original copy or the certified copy from the registrar of the power of attorney. What we had annexed was the exhibit that was marked in the other case, a certified copy of that of the power of attorney in this matter, which is going on before this honorable court, which is pending. And the substantial question of law that has been framed with that may be seen, Your Ladyship.
It just can't be like this. It is not arising out of the same suit. We have to see the impact.
Yes,
And if you want to rely upon any such
Your Ladyship, but the question of law regarding adoption has been settled by that, by the judgment that I just passed to you, and also the power of attorney had been held to be maintainable.
there is a substantial question of law here.
Order dated
Has
21st.
any substantial question of law been framed on the point of power of attorney?
No, Your Ladyship, but it has said 21st.
If there is no such substantial question of
They
law,
have
there is
said
no
that the power of attorney holder did not have the power to depose. If I may be permitted to read the substantial question of
question.
law.
You read it.
21st January 2020 order.
Yes.
Whether the appellate court below has failed to consider the well-settled legal proposition that the power of attorney holder cannot depose in place of the principle in view of the provision of Order 3, Rule 1, which empowers
It is only
to act on behalf of the principal.
it is only deposition. The power of attorney per se is not under charge.
Yes, it is not under charge.
Then this is the only question
How
of law.
both the
How
cases
this?
are differentiated, Lordship?
No, we will not mix these two cases in this manner. The writ petition थोड़ी है उसमें आपको order मिल गया तो इसमें लगा.
The same party and same suit property was involved, and same
The
power
only
of
thing
attorney.
maybe that has no relevance.
Very well.
The importance of examination of power of attorney is as to whether he is deposing something
Which he could not have.
which he could not. That is it. There is no legal bar.
Very good.
There is no legal bar, power of attorney deposing. But the point is, what is he deposing? Correct?
Yes, sir.
So,
Which I was doing for pass.
इतना अच्छा दिन है, आपको मौका मिला है, आपको पास ओवर चाहिए. वीकेंड के बाद वीकेंड में आपको क्या करते
I mean, Lordship, I have gone through the case.
Not really to start. Start.
Lordship, appeal has been admitted by the order dated 21st January 2020. substantial question of law has been just read over. May I repeat, Lordship?
Yes, please.
Whether the appellate court below has failed to consider the well-settled legal proposition that power of attorney holder cannot depose in place of principal in view of the provision of Order 3 Rule 1 CPC, which empowers the holder of power of attorney to act on behalf of the principal. So the short facts of the case are that we are the defendants, Lordship. The plaintiffs have filed suit on 24/7/2005 for a decree of recovery of possession by evicting the tenants, that is us, Lordship. Suit property was purchased by the adoptive father of the plaintiff's, Lordship. By two deeds dated 19/2/58 and 9/4/59.
Just a moment. Let us see the case of the respective parties. Read it from the eviction suit.
May I read it?
Yes, please.
Instead case has been filed by the plaintiff for a decree of recovery of possession of the suit premises described in the schedule of the plaintiff, evicting the defendant therefrom. Suit premises is the 3 rooms, a kitchen, a toilet in the first floor of the building standing on western portion of plot 4832, Khata 776, ward number 9, Mauza Mango, PS Jamshedpur. Plaintiff's case in brief is that portion of the building standing on the piece and parcel of land measuring more or less than 4 kattas, being a portion of RS plot 4832, so and so, more fully described in Schedule A of the plate situated within the jurisdiction of this court, is the subject matter of the suit. Late Parvati Kumar Das purchased a piece and parcel of land measuring 7 katta 15 decibels from Vibhishan Gaur, Kokil Gaur, Shyam Gaur and Kanhai Gaur by means of registered deeds of sale dated 19/2/58 and 9/4/59, being portion of CS plot 81 and 46 Mauza Mango in the name of his wife Biroja Bala Das, and both of them came in possession of the said purchase. Aforesaid Parvati Kumar Das constructed a double-story building over the aforesaid purchased land. As Parvati Kumar Das and his wife Biroja Bala Das had no issue of their own, therefore they adopted the plaintiff in near relation as the son in or about the year 1948. All rituals and ceremonies necessary for adoption were performed, and the natural parents of the plaintiff were personally present. The adoption was made on Makar Sankranti Day, that is on 14 January 1948, which is considered as an auspicious day of Hindu. At the time of adoption of the plaintiff was 4 years old, and since then the plaintiff has been residing with Parvati Kumar Das and Biroja Bala Das as their adopted son. The plaintiff was admitted in Ramakrishna Vivekananda School, Sakshi, Jamshedpur in 1949 by his adoptive father, Parvati Kumar Das. Therefore, in the record of school and in all other concerned records, the name of Parvati Kumar Das appears as the father of the plaintiff. Aforesaid land purchased in the name of Biroja Bala Das and the building constructed thereon by her husband Parvati Kumar Das came to be recorded in the name of Biroja Bala Das in the record of right, finally published in the year 1964, as well as in the record of right finally published in the year 1979. It has been recorded in plot number 4832 and Khata number 776 in the finally published record of right in 1979. Aforesaid Parvati Kumar Das and Biroja Bala Das were in peaceful possession of the land and the house standing thereon. Biroja Bala Das died in the year 1977. Thereafter, her husband Parvati Kumar Das predeceased her. After the death of Parvati Kumar Das and Biroja Bala Das, the plaintiff, being their only legal heir and successor, came in possession of the aforesaid land and house standing thereon as absolute owner thereof. While the plaintiff has been in peaceful possession of the entire land measuring 7 katta 15 rods and the building standing thereon, he inducted several tenants and was realizing rents from such tenants and has been paying electricity and other charges. While possession of aforesaid property as absolute owner thereof of the plaintiff, transferred 3 katta and 15 rods of land in the western portion of the aforesaid land along with buildings standing thereon in favor of Srimati Sulekha Mandal, wife of Sushant Kumar Mandal, by two registered deeds of sale bearing deed number 5912 dated 27/8/90 and sale deed number 1318 dated 16/3/93. But if these two sale deeds were the matter of dispute in the second appeal that has been mentioned.
These two sale deeds have been set aside.
No, Lordship.
So they have been upheld.
Yes, Lordship. Srimati Sulekha Mandal and her husband Sushant Kumar Mandal are in physical possession in the suit in the portion purchased by them without any interference from anyone as absolute owner thereof. It may be mentioned here that prior to the aforesaid purchase, Sushant Kumar Mandal was in occupation of the aforesaid portion of building as a tenant under the plaintiff and used to pay rent to the plaintiff. After aforesaid transfer made in favor of Sulekha Mandal, the plaintiff has been in possession of the remaining portion of land measuring 4 katta and the plaintiff and the building standing thereon as absolute owner thereof. Plaintiff has been inducting tenants and realizing rent from such tenants in the portion which remained in his possession and possession after aforesaid transfer made by plaintiff in favor of Sulekha Mandal. The father of the defendants, late Suresh Chandra Das, was passing hard days in the same village at 24 Pargana, where he came as a refugee from the then East Bengal. He came to Jamshedpur in search of job, but out of sympathy and considering their relationship with Biroja Bala Das, he was allowed to live in a portion of first floor of the building with leave and license of Biroja Bala Das and her husband in the earlier part of 60s, since the lifetime of Parvati Kumar Das and Biroja Bala Das. Parvati Kumar Das also helped him to secure a job in Telco Limited. Parvati Kumar Das at that time was a permanent employee of Tisco Limited. After the death of Parvati Kumar Das and his wife Biroja Bala Das, aforesaid Suresh Chandra Das continued in permissible possession of the suit portion of the building as licensee under the plaintiff. Aforesaid portion of the building, which was an occupation of aforesaid Suresh Chandra Das, is described in Schedule A of the plaint and is the subject matter of this suit. Suresh Chandra Das died in the year 2000. After the death of Suresh Chandra Das, the defendant, being his sons and legal heirs, continued in possession of the said portion as a licensee under the plaintiff. Suresh Chandra Das filed title suit 37 of 93 in the court of Munship at Jamshedpur, in which the plaintiff was defendant number 1 and aforesaid Sushant Kumar Mandal and his wife Sulekha Mandal were defendant number 2 and 3. Aforesaid suit was filed by Suresh Chandra Das challenging the validity of aforesaid sale deed number 5912 dated 13/7/90, 27/8/90 in favor of aforesaid Sulekha Mandal, defendant number 3 in that suit. And in the said suit, said Suresh Chandra Das filed a petition for temporary mandatory injunction directing defendants of that suit to remove the water tank fixed on the roof of the building and construction made thereon, which, after hearing the parties by order dated 12/4/96, the learned Munship at Jamshedpur had been pleased to reject. The leave and license for residing in the suit premises was granted only to Suresh Chandra Das by Biroja Bala Das and his husband. As submitted above, said Suresh Chandra Das continued as licensee under the plaintiff. The aforesaid license was granted to Suresh Chandra Das, which is not transferable or heritable. After the death of Suresh Chandra Das, the plaintiff requested the defendants to surrender the suit premises and give vacant possession to the plaintiff, as license granted to Suresh Chandra Das stood revoked after his death. The defendants are on one and other pretext took time to vacate the suit premises, but ultimately on 1st July 2005, they refused to vacate the same. Hence this suit. Plaintiff is entitled to a degree of recovery of possession of the suit premises more fully described in the schedule of the claim, evicting the defendants therefrom. It may be mentioned here that Suresh Chandra Das brought into existence a will purported to have been executed by Srimati Biroja Bala Das, bequeathing the aforesaid property in favor of the plaintiff as well as Suresh Chandra Das. The alleged will is forged, fabricated, manufactured document which have been brought into existence by Suresh Chandra Das in order to grab the aforesaid property of Biroja Bala Das. Suresh Chandra Das filed an application for grant of probate on the basis of aforesaid will in the Court of District Judge in Jamshedpur, registered as probate case number 105 of 93. The plaintiff appeared in the aforesaid probate case and filed objection to grant of probate as such aforesaid probate case came to be registered at title suit 1 of 97. Lordship, miscellaneous appeal pertaining to this grant of probate case is also pending before this one.
The probate case was dismissed.
But
During the pendency of said title suit number 1 of 97, Suresh
is
Chandra
that miscellaneous appeal? MA number?
MA number 157
Of 2014.
2014. Most probably it is listed day after tomorrow.
Yes, continue.
During the pendency of said title suit 1 of 97, Suresh Chandra Das died, and after his death, the defendants, along with their sisters, filed petition for
This
substitution.
title suit was dismissed.
Yes, Your Lordship. And in view of that fact, the matter is sub judice for consideration of the court whether those legal heirs are entitled to be grant of letters of administration. The said aforesaid title suit number 1 of 97 pending in the court of additional district judge come fast track 6 exemption for defendants have no manner of right or interest to continue in possession of the suit premises. Cause of action of this said suit arose against the defendants on and from 22/4/2000, the date of death of Suresh Chandra Das, and on and from 1st July 2005, when the defendants refused to vacate the suit property. For the purpose of court fee and jurisdiction, suit is valued at ₹30,000. After admission of the case, notice was issued to the defendants, which they appeared and filed written statement dated 6/1/2006. Defendants in the written statement stated that the suit is not maintainable in its present form and for the relief sought. Plaintiff has no cause of action or right to bring the suit. Suit is barred by limitation. The suit is that inasmuch as it has been registered as eviction suit against the defendant, though there is no mention of any tenancy agreement between the plaintiff and defendants. The suit filed against the defendant as licensee and thereof the suit should have been registered as title suit against the defendant, but the plaintiff with an ulterior motive has put the title of the suit as eviction suit. The suit is barred by the provisions of Specific Relief Act, inasmuch no relief can be granted as prayed for in the present suit without compliance of Section 34 of the Specific Relief Act. On perusal of the claim, it is found that Sushant Kumar Mandal, presenting himself as constituted attorney, has signed the claim of the present suit, which he has no authority to sign, and present the plaint in the court. Said Sushant Kumar Mandal has not filed the original power of attorney in the court, nor he has sought any permission from the court to sign the present suit on behalf of Gokul Chandra Das, and as such the plaint is liable to be rejected. Suit is barred by non-joinder of necessary parties, as Suresh Chandra Das had died leaving behind 2 sons and 4 daughters on 22/4/2000, and all the heirs of Suresh Chandra Das have not been made party. Hence, the suit is liable to be dismissed for non-joinder of parties. The plaintiff has not filed original sale deeds or certified copy of sale deed dated 19/2/58 and 9/4/59 to show that as to which of the land has been purchased in the Benami name of Biroja Bala Das. It is true that Biroja Bala Das purchased land in new plot number 4832 Khada 776 of Mauza Mango by 2 separate deeds, but it is false to suggest that Parvati Kumar Das constructed double-story building over the aforesaid purchased land. It may be mentioned that father of present defendants had also contributed some amount in the construction of building standing in the suit law. It is true that Parvati Kumar Das and Biroja Bala Das had no natural born son. Both Parvati Kumar Das and
As we have
Biroja
understood the contents of the dispute, now you come to the issues.
issues at page 42. Lordship.
Yes.
On
And
the
which
basis-
issue is important so far as this substantial question of law is concerned?
So it will be first on whether the suit is maintainable in present form as per relief claim, and whether
Number
the
one.
plaintiff has a first one will be
Let us see how issue number 1 has been decided. What about all other issues which were decided against you and which were in your favor?
Lordship, all were decided against me. Lordship.
All issues were decided against you.
Yes.
And suit was decreed.
Suit was decreed. Lordship.
What about the appellate court? Let's see issue number 1 and 2. Where is the discussion regarding power of attorney? And where is your objection regarding power of attorney discussed?
Lordship, issue number 1 and 2 has been decided jointly at page 48. Internal page
That's
16.
why it is a short order. It is not talking about power of attorney at all.
Yes, Your Lordship.
So, where is the discussion with regard to power of attorney?
Lordship, that has been dealt with in para from page 12, Lordship, last paragraph.
The last bracket. Yes.
There's a
Please
long
read.
paragraph, Lordship, starting from there.
Yes.
It has been contended that since title of the plaintiff is disputed, eviction suit will not lie, rather declaratory suit will lie. Title of parties cannot be decided in eviction suit. It is beyond the jurisdiction of this court. It was settled proposition that in eviction suit parties.
It was filed under BBC.
Yes, Lordship.
No, it is not under BBC Act.
No, Lordship.
It is not under BBC Act. Correct? Yes, please continue reading. No, law researcher का है? Yes, please continue.
Should be left to get the complicated question of title decided in properly framed civil suit. In eviction suit, title of the parties is not required to be decided in full
This is
fledged.
irrelevant.
Towards the next
This-
page, this will be dealt with the power of attorney.
No, I just want to continue reading, but otherwise this argument is irrelevant.
Yes. Lordship, may I directly draw your Lordship attention to the next page, Lordship. Next page, top paragraph, Lordship, somewhere around 10th line in the first paragraph. Exhibit 5. Exhibit 5 is the certified copy of power of attorney dated 19/11/1988. 10th line from the top, Lordship.
Internal,
Internal
running page
page
46. 46?
Yes, Your Lordship.
Yes, exhibit 5.
Exhibit 5 is the certified copy of power of attorney dated 19/11/1988 with objection. In para 22, 21 and 22 of his cross-examination, DW1 admitted regarding the dispute of land with father so-and-so. After that, father substituted as party in both the cases, and in both cases, Sushant Kumar appeared on behalf of plaintiff being power of attorney, and he has not raised objection in the said cases. From above discussed, in the case for determining landlord, it is found incidentally that plaintiff is the owner. That is all that has been dealt, Lordship.
So, how does it relate to the substantial question of law?
Lordship, now the power of attorney over here is deposing related to purchase of suit
I
property
want
back
to
in.
know that this particular finding, how does it relate to the substantial question?
This has not been properly dealt with.
That is
Not
not
dealt.
your case before the learned trial court.
Lordship, we had raised an objection. The learned.
What about the first appellate court? Let's have a look at it. Was there any this point of determination framed with regard to power of attorney?
The appellate court has rediscussed the issues, Lordship.
So where is your argument with regard to objection of power of attorney deposing? You see, it is not a case where the power of attorney itself is disputed. It is a case where power of attorney is deposing, and you have objection with regard to the fact that the power of attorney is deposing and the plaintiff is not.
Lordship, we had objected power of attorney also since the
That is
original.
not the substantial question of
Yes.
law. So we are not bothered about it. Power of attorney is an admitted document from the records, right? Now, whether the power of attorney could have deposed in place of the plaintiff is the issue concerned. Okay.
Our argument is in para 9, Lordship. Internal page 9.
Okay.
Learned counsel appearing on behalf of the appellant submits that the court below has committed error in law in passing and fact in passing the impugned judgment and decree. It is stated that firstly the court below failed to consider the most dominant aspect of the case in terms of Order 3 Rule 1 CPC, where the law is settled that the power of attorney holder cannot prosecute a case and non-examination of principle will have vital adverse effect to the case of the plaintiff.
Is it a universal law?
No, Lordship, it depends on case to case, Lordship.
So there is no legal bar as such that power of attorney cannot be used.
It has to
वो बोल रहे हैं जी बुक नहीं एक हम लोग स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट में पावर ऑफ अटॉर्नी के डिपोजिशन पर जजमेंट आप ही का केस था मैडम पावर ऑफ अटॉर्नी योर केस
My colleague had done it.
Who?
Pooja had done it.
Who had done it? Ask her to give the name.
Lordship, this was the judgment cited in that case, Lordship.
Your Lordship, Pooja had not done that matter. I think somebody else then from the office. I'll inquire and I'll get back to you.
हम मनाते हैं बुलाइए मेरा बोला जी yes please continue. So it is not a universal law.
Yes, Lordship.
Adi. It is also
It
stated.
is stated that firstly the court below failed to consider the most dominant aspect of the case in terms of Order 3 Rule 1 CPC, where the law is settled that power of attorney holder cannot prosecute a case and non-examination of principle will have vital adverse effect to the case of the plaintiff. It is also stated that the court below also considered the fact that plaintiff respondent was only a foster son and not adopted son, and this part of the case was neglected by the court below while passing the impugned judgment. It is also stated that by marking the certified copy of power of attorney as Exhibit 5 was not in accordance of law, as the same was not a public document and could not have been taken into evidence. It was certified copy of an exhibit which was marked by the court of competent jurisdiction in another proceeding, and it was not the certified copy of the registered document obtained from registration office, which can be considered to be a public document. It is stated that original power of attorney could have been withdrawn from the said case and could have been filed in the suit by substituting the original power of attorney by certified copy of the exhibit. But in this case, the plaintiff respondent has not done the same and has acted contrary to the mandate of law by getting certified copy of exhibit marked as exhibit in this case. Learned counsel further submits that the authority of Sushant Kumar Mandal itself was bad, and therefore the entire case of the plaintiff was bound to fail. It is stated that said Sushant Kumar Mandal was not competent witness to depose on behalf of the plaintiff on the point of adoption, which was a fact of personal knowledge of Gokul Chandra Das. No person on the point of adoption has been examined. It is stated that since there was an adoption despite the natural line of succession, hence burden of proof was on the person claiming to be the adopted son of the recorded owner to prove that there was a legal and valid adjudication adoption. In this case, in the absence of any registered document of adoption, no presumption of valid adoption can be drawn, and in absence of any presumption, the burden of proof was on the plaintiff, Gokul Chandra Das, to prove that he was the adopted son of Birojawala Das and Parvati Kumar Das. The plaintiff not being examined in this case, and the person examined on behalf of the plaintiff, admits to have met Gokul Chandra Das for the first time in the year 1962. Hence, he was not a competent or proper witness on the point of adoption. It is also stated that a person who is acquaintance with Gokul Chandra Das from 1962 was not competent witness to say about the activities which took place prior to 1962, and hence this aspect of the case alone was sufficient to dismiss the suit. Prayer is made that the appeal may be allowed and the impugned judgment and decree may be
पावर ऑफ अटॉर्नी के एविडेंस लेने पर एक जजमेंट लेते हैं स्पेसिफिक परफॉर्मेंस का केस था वेदर ही कैन डिपोज ऑन बिहाफ ऑफ द प्रिंसिपल उसमें 2-3 जजमेंट्स हमने रेफर किए थे कि अंडर बहुत सर्कमस्टांसेस जो पर्सनल नॉलेज वाले रहते हैं वो सारी चीज़ें वो नहीं डिपोज कर सकते या तो स्पेसिफिक परफॉर्मेंस का था या फिर वो अटॉर्नमेंट का था पावर ऑफ अटॉर्नी मतलब आपको मिल जाएगा सर्च करेंगे यस
Per contra, the learned counsel appearing on behalf of the appellant respondents submits that the court below has not committed any error of law or fact in passing the impugned judgment. It has stated dominant question raised by the appellant in course of argument is authority to Sushant Kumar Mandal to depose on behalf of Gokul Chandra Das or to bring the suit on behalf of Gokul Chandra Das. And this being the dominant and pertinent question in this case is required to be examined on a priority basis. It is stated that the fact that the power of attorney was executed is not in dispute. It is also stated that on the said basis, power of attorney, the present plaintiff Sushant Kumar Mandal has been prosecuting the case on behalf of Gokul Chandra Das in different forums and other cases, that is the suit for cancellation of sale deed, which was also executed on the strength of power of attorney, has been dismissed, and the first appeal has also been dismissed, which is an admitted fact as it has come in course of argument. It is also stated that a probate case was also contested by the present attorney holder of the principal Gokul Chandra Das, as a result of which the probate case became contentious and it was converted into title suit, and finally the suit was dismissed. The learned counsel therefore submits that there is no legal power of attorney holder deposing and contesting the case on behalf of the principal, or even the provisions of CPC does not create any bar in respect of the same. It is further stated the fact that Biroja Wala Das was the owner of the property in question is not in dispute, and the fact that plaintiff Gokul Chandra Das was the foster son of Biroja Wala Das is also admitted. Therefore, the fact of the plaintiff living with the recorded owner as their son is an admitted fact. The only dispute is whether his status was that of a foster son or an adopted son. Apart oral evidence, there is no documentary evidence on record on behalf of the appellant to support the contention that Gokul Chandra Das was a foster son. On the other hand, there is documentary evidence on record in the form of Exhibit 2, 3, 3/8, where the name of present plaintiff Gokul Chandra Das has been shown as the son of Parvati Kumar Das. The foster son cannot be shown to be the son of recorded owner, and this evidence has a legal presumption which, with regards to the capacity of the original plaintiff, that is principal plaintiff, and that he was the legal class 1 heir of the deceased Parvati Kumar Das and Biroja Wala Das. It is true that evidence of giving and taking has not been brought on record, but the act of adoption is alleged to have taken place on 14/1/1948, and the litigation between the parties commenced since 1993. And since then, Sushant Kumar Mandal, claiming himself to be the power of attorney holder of Gokul Chandra Das and Biroja Wala Das, has been claiming to be adopted son of Parvati Kumar Das and Biroja Wala Das, but unfortunately, till date, no suit has been brought by the defendant for declaration that plaintiff is not the adopted son of Biroja Wala Das and Parvati Kumar Das. Learned counsel therefore submits that once the owners prove that the plaintiff is the son of Biroja Wala Das and Parvati Kumar Das, was discharged by producing Exhibit 2 and 3, which are documents of the year 1949, and thereafter, and that there is no rebuttal to this evidence. Mere assertion that document is forged, fabricated, does not amount to rebuttal of the proof brought on record on behalf of the plaintiff. Thus, learned counsel submits that the question of competence of original plaintiff, that is principal plaintiff Gokul Chandra Das, to bring a suit for ejectment of defendants as son of the recorded owner Biroja Wala Das and Parvati Kumar Das, was rightly decided by the court below. Learned counsel further submits that the second objection relates to the authority of Sushant Kumar Mandal to depose in this case on behalf of the principal Gokul Chandra Das. Learned counsel submits that there is no legal bar for the same, and therefore the question is also decided. Learned counsel thereafter submits that legal status of the defendant is admittedly that defendant or his father was not the recorded owner of the property, and they are not the class 1 heirs of the deceased recorded owner, and in the presence of plaintiff they cannot have superior right of succession over the suit property. Thus, the status of defendant at the most can be considered to be that of a licensee to be in permissive possession of the suit property, which permission license has been revoked and the suit for rejectment has been filed. Therefore, it is rightly held by the trial court that they are liable to be evicted from the suit property. Learned counsel has placed reliance on the judgment of Jharkhand High Court reported in also, wherein it has been observed that adverse inference for non-examination of an oral witness cannot be drawn if there is other cogent evidence on record. The learned counsel refers to the judgment of Honorable Supreme Court, which is also on Section 114 of Limitation Act, where the Honorable Apex Court has observed that the question of drawing an adverse inference against the parties on account of their absence from the court would arise only when there was no other evidence on record on the point in issue. Reliance has also been placed on judgment reported in 1977 AR page 472 where Apex Court has observed that adverse inference of non-examination of party can be drawn only if there is no valid explanation of non-examination of said party, and in this case the suit was brought originally by power of attorney holder and hence no inference can be drawn. Reliance has been placed on the judgment reported in AIR 1974 Patna 95 where Honorable High Court has observed that if there is no inherent defect, then non-examination of the plaintiff is not vital to the case of the plaintiff. Lastly, Reliance has been placed on a judgment reported in 1993 AIR Calcutta 399 where the Honorable High Court held that if a person fully acquainted with the facts of the case deposed on behalf of the parties, no adverse inference can be drawn for a non-examination of the party. Where is made to dismiss the appeal as it does not have any meaning.
See, the suit was filed by
Power of attorney.
just a minute. Gokul Chandra Das being the power of attorney holder
No. He was the
Gokul Chandra Das is the foster son on whom the property has lived. Through him, Sushant Kumar Mandal had
through Sushant Kumar Mandal. Sushant
He is
Kumar
the
Mandal
power.
was the power of attorney.
Yes.
Now, you just come to running page 35.
35.
Right. Now, there was a sale deed, two sale deeds, in favor of Sulekha Mandal,
and Sushant Kumar.
wife of Sushant Kumar Mandal, right? Two registered sale deeds.
Yes, sir.
And since then, the purchaser Srimati Sulekha Mandal and her husband Sushant Kumar Mandal are in physical possession in the portion of the property purchased by them.
Lordship, since the date he purchased that property, he was well aware of all the proceedings that are going on within that property and with the family. But before this date, before the execution of sale, he was not aware with respect to adoption.
Is the property involved in this case a part of the property involved in the sale deed or not?
Lordship, the sale deed that was executed in favor of Sushant Kumar Mandal was a part of this property.
Was a part of the scheduled property.
Yes, sir, Lordship. Earlier, this property consisted of 7 acres.
Schedule B is a part of this sale deeds. Schedule B is a part
Lordship,
of
there is
this-
only Schedule A.
Sorry, Schedule A is a part of this sale deed.
No, Lordship.
It is
Schedule
not.
A is different. We had sold a part to Sushant Kumar Mandal. That is a part of that sale deed.
Okay.
And on the rest remaining part, we are
You
deciding.
sold that property. This property was sold to Sushant Kumar Mandal on the strength of a power of attorney.
Yes, Lordship. Sushant Kumar Mandal himself executed the deed in favor of himself.
in his favor of his
Yeah.
wife in relation. So in
Two deeds. One is-
1958, the land was bought by Parvati Kumar Das in relation. Thereafter, he was continuously in possession. So that when he had purchased it, he had purchased 7 kattha 15 dhur. Subsequently, in the year 93 and 1990, Sushant Kumar Mandal, being the power of attorney holder of Gokul Chandra Das, who was the son of Parvati Kumar Das, the foster son, he executed 2 sale deeds and he sold 3 kattha 15 dhur of land to Sulekha Mandal. But that is not a subject matter here. Here we are with respect to 4 kattha of land on which the building is standing, in which on one part
And
the
now same
plaintiff had
Sushant
taken it.
Kumar Mandal is acting as
The
Power
power
of
of attorney holder. Continuously, he's the only one who has been acting as the power of attorney holder. And the same power of attorney has been upheld in SF 635 and as well as in the probation case. And in this instant matter, the exhibit 5 which has been marked is the certified copy of the exhibit that was marked
so there
in
is no
title
objection
suit.
to that.
Yes.
The point is whether he could have deposed.
Your Ladyship,
Is there any issue as to whether there was adoption or not?
no, Your Ladyship, they have in fact
Is
admitted.
there any issue
Lordship,
that
we are
whether there
claiming
was
that he
any
was a
adoption or
foster
not?
son.
Thank you.
We are only claiming that he is a foster son, while the respondents are claiming that he is an adopted son, and both the courts have come to a finding that he was an adopted son because the records of the school show.
Has any issue been framed whether he was a foster
Yes.
son or was an adopted
It's
son?
not in this.
that will be dealt in issue number 6, whether the plaintiff has any right, title and interest over the suit land. I'll just read it once.
The matter regarding adopted son is already set at rest in issue.
Issue number 7 and 8 was. Let me just read it together. Issue number 6 and 6. Actually, in that respect, issue number 6 has been decided, but it does not deal with adoption.
The leadership in the appellate court order, they have dealt with this part specifically on the basis of the cross-examination of the appellate hearing. That he has admitted that he was the foster son, but he was treated as a son and was kept with him.
We have also contended that we were the ones who had brought that son from Bangladesh.
Read issue number 7 and 8.
Should I start from the second paragraph?
Yes, para number 9, the internal page 43, running page 43. The defendants,
Though disputed the ownership of the plaintiff, has stated that their father Suresh Chandra Das was the own brother of Biroja Bala Das, and the plaintiff being foster son of
slow, but if it's
Defendants, though disputed the ownership of the plaintiff, has stated that their father Suresh Chandra Das was the own brother of Biroja Bala
whose
Das.
father Suresh Chandra Das?
Defendants.
Father.
Defendants' father.
Okay.
And the plaintiff being the foster son of Parvati Kumar Das and Biroja Bala Das. Parvati Kumar Das and his wife Biroja Bala Das and their father Suresh Chandra Das were originally residents of Bangladesh since their childhood, and when they came to Jamshedpur from Bangladesh, his father used to reside at Jamshedpur with Parvati Kumar Das and Biroja Bala Das. Their father was never a licensee, rather their fathers spent substantial sum in construction of the suit premises. In respect of the house in question, the plaintiff is not the owner of the same. Rather, after the death of Biroja Bala Das, his father, as being class 2 heir of the deceased Biroja Bala Das, became the owner of the land and building. The only bone of contention is that plaintiff is landlord or not. Plaintiff claims that late Parvati Kumar Das and his wife Biroja Bala Das had no issue of their own. Therefore, they adopted plaintiff in the relation as a son in or about the year 1948, and their adopted father of plaintiff, namely late Parvati Kumar Das, purchased a piece and parcel of land measuring 7 katta 15 rows from Vibhishan Gaur, Kokil Gaur, Shyam Gaur and Kanhai Gaur by means of registered deeds of sale dated 19/2/58 and 19/4/59, being portion of CS plot number 81 and 46 of Mauza Mango in the name of his wife, Biroja Bala Das, and both of them came in possession of the said purchased land. Thereafter, adoptive parent of the plaintiff constructed double-storied building over the said aforesaid purchased land, and the suit plan was recorded in the name of Biroja Bala Das, right, finally published in the year 1964, as well as in the record of right finally published in the year 1979. It is admitted fact that Biroja Bala Das died in the year 1977, and the husband Parvati Kumar Das had predeceased. After the death of his adoptive parent, plaintiff, being the only legal heir and successor, came in possession of the aforesaid land and house. Plaintiff in his plaint has stated that father of defendants, Suresh Chandra Das, was passing hard days in the same village at 24 Pargana, where he came as a refugee from East Bengal to Jamshedpur in search of job, and out of sympathy and considering the relationship with Birojawara Das, he was allowed to live in a portion of first floor of the building with leave and license of late Birojawara Das and her husband in the earlier part of the 60s. Since in the lifetime of Parvati Kumar Das and Birojawara Das, they helped him to secure a job in Tisco Limited because Parvati Kumar Das at that time was a permanent employee of Tisco Limited. After death of his adoptive parents, defendant's father, Suresh Chandra Das, continued living in permissible portion of the building as licensee under the plaintiff.
So the defendants are claiming to be the successor also.
Class 2 successor. We were the own brothers of Birojawala Das, mother of the plaintiff.
And now, plaintiff is claiming to be the adopted son.
Adopted son.
So you want to say that this adoption was required to be given,
Yes, Sir.
and therefore the power of attorney could not be used.
Similarly, with regard to purchase of the land back in the year 1959, the power of attorney had no personal knowledge of the same. Though it was held in the other case because it was related to inception of the sale deed. Since inception he had knowledge, hence it was upheld in the other case. However, in this case, Lordship, since the purchase of property in 1959, the power of attorney had no personal knowledge of the same, neither regarding adoption or admission of the plaintiff in any of the school. Hence, his deposition could not be.
Power of attorney entered into picture only in the year 1962.
Yes, Lordship.
Prior to that, an adoption is claimed to be of the year 1948.
1948.
So therefore, according to you, the plaintiff was required to be cross-examined, and if he could have, he may have proved, may not have proved, but if he failed to prove his adoption, then under such circumstances, you being the class 2 here, would inherit the property and be there on your own.
Yes, however, the probate which we have filed, Lordship, in that we have
Probate is a different issue.
we have stated that the property has been given to the defendants as well as the plaintiff as well.
The probate, we are not bothered about it. If pursuant to probate, you get something, that is a different thing altogether. But when it comes to cross-examination of the plaintiff in person, and when there is a dispute that as to whether there was any adoption or not, then that adoption was required to be proved. And so far as the adoption is concerned, the court has come up with a plea that the documents of the year 1948 itself revealed that the name of the father was shown as Parvati Kumar Das.
That is true, Lordship, but the documents need to be proved by oral evidence also, and that oral evidence can be given only by the plaintiff himself who had the personal knowledge of this.
This oral evidence, this is 30 years old document. These are more than 30 years old documents. So there is some presumption attached to it. Right. So this document.
Regarding the purchase, which Birojawala Das and Parvati Kumar Das had purchased, the sale deeds have also not been brought on record.
So how does that?
Although they are a public document, Lordship, since they are contending that in the claim, they have to be proved, and oral evidence in that regard has to be.
We are not on that. We are not. We are on the point as to whether he was to be necessarily examined in person.
Yes, sir. Regarding sale deeds also, since they are mentioning that they had purchased the suit in the year 1959, the same has to be substantiated through.
They had purchased not the suit property. They had purchased another property.
No, Lordship, suit property.
No, you
Entire
say
seven
that
katta.
this sale deed was relating to some other property.
Lordship, initially 7 katta, 15 those was purchased by the parents of the plaintiff, and from that part, 3 those was sold off to the power of attorney. So it was a big land. Chunk of land has been sold to the power of attorney, and the remaining part it remains in our possession. So that deed has not been produced.
Out of 7 dhur, 3 dhur were sold to Sulekha Mandal. In 4 dhur, there is a building. On part of that building, only 3 rooms have been occupied by the defendant. The rest of the portion of the building, whomever we have given them as tenant, whenever they vacate or whenever they are residing over there, they have given us the rent, or whenever they leave, they give us back the possession. We are in possession
No,
of the
your relationship with third parties may not have any relevance over here, because for the purposes of creation of tenancy, title is not to be required to be proved, right? Whosoever is acknowledged as a landlord, he deals with the property.
Lordship, regarding inducting more tenants also, power of attorney is not assigned with inducting of tenants. That is also done by the plaintiff himself. So if at all he is contending, that has to be sent by the power of attorney, by the plaintiff himself. Lordship.
हाँ सर, रिवर्स मोड में चलेगा क्या? सीनियर जूनियर को असिस्ट करेंगे। यस।
कभी कभी इन लोग को भी तो
नहीं अच्छा, बहुत अच्छा, हम तो जानते हैं अच्छा बहस करते हैं, इसलिए हम बोले कि आप बहस करिए। Is what he has argued is, as I could capture, he says that the defendant himself was claiming title over the property, being the class 2 here, and the plaintiff was claiming to be the adopted son, and therefore the plaintiff was required to be examined and not his power of attorney, because adoption is of the year 1928, and the power of attorney came into picture only in the year 1962. So he cannot have any personal knowledge so far as the adoption is concerned. This is his case, in short. But at the same time, the respondent would contend that there was enough documentary evidence to show that there was adoption, and particularly the document regarding the school certificates, etc., showing that the name of the father. So, under such circumstances, was any further document required to prove adoption? Anyways, let me hear it. But then,
First and foremost, I would like to draw your attention to the appellant's court order, civil appeal number 70 of 2018. Page 6 may be seen, para 5, oral and documentary evidence.
yes.
13th line from below your lecture, on page 6. He admits the institution of title suit number 1 of 1997, where he was substituted after the death of his father, and also admits at para 22 that both the title suits instituted by him or his father was contested by Sushant Kumar Mandal as power of attorney holder of Gokul Chandra Das. At para 29, he admits
Who was
that
substituted after
Your
death?
Lordship, Suresh Chandra Das, after that, he was substituted by his son, who is the appellant in this second appeal. At para 29, he admits that Gokul Chandra Das is foster son of Viroja Bala Das and Parvati Kumar Das. He says that documents where the plaintiff is shown to be the son of Parvati Kumar Das and Viroja Bala Das has been marked exhibit with objection. In further cross-examination, he says that in title suit number 1 of 1997, Gokul Chandra Das was shown to be the foster son, and in cross-examination, he has admitted that Gokul Chandra Das was treated as son. At para 35, he says that foster son means the child who is brought up by the foster parents but no a natural child. Then he says that he is ignorant with regard to the father's name of the plaintiff as Parvati Kumar Das. At para 41, this witness says that in the will it is written that Gokul Chandra Das was a foster son. He admits that title suit number 37 of 1993 was dismissed, against which appeal has been filed. At para 47, he admits that the house where he is staying is in the name of Viroja Bala Das and Parvati Kumar Das, who is the husband of Viroja Bala Das. He also denies the father of the Gokul Chandra Das is Dengur Das. He can produce the document in respect of the same. Apart from that, there is nothing significant. So he has not brought on record any document denying that I am not the
just
adopted son.
Sushant Kumar Mandal, at paragraph 29, He admits that Gokul Chandra Das is foster son of Viroja Bala
Not
Das and
Sushant
Parvati.
Kumar Mandal, Sushant Kumar Das. Sushant Kumar Das is the son of Suresh Chandra Das, who is the
You
class
see,
2
at
head.
para 29, he admits that Gokul Chandra Das is foster son of Viroja Bala Dasi and Parvati Kumar Das.
He admits, he here is
He means what?
Sushant Chandra Das. The
No, Sushant
appellant.
Kumar Mandal. The entire discussion is about the evidence of Sushant Kumar Mandal, the power of attorney holder.
Your Ladyship, the lower
Let's see power PW1, right?
Yes, Your Ladyship.
ये कौन सा पैराग्राफ को रेफर करना है? He admits in para 29, he admits that Gokul Chandra Das is foster son of Viroja Bala Dasi and Parvati Kumar
Title
Das.
suit number 1 of 1997, which was marked as an exhibit in this case.
Evidence,
Yes, the evidence it was marked.
which is that exhibit?
Exhibit is your Ladyship. Exhibit 9, your Ladyship.
In his cross-examination, he is clearly saying that Gokul Kumar Das has disclosed that he is the adopted son. Then he says that from the parents of Gokul Kumar Das, he came to know that Gokul Kumar Das has been adopted. But where is Gokul Kumar Das for cross-examination?
Your Ladyship, he was very sick and he could not come. And
Where is that
therefore
explanation?
We have brought it on record. We have
Is there
stated
any
that.
law that sick person cannot be examined?
Your Ladyship, We have stated that he
Commission
was,
would be appointed for this cross
Your
examination.
Lordship, but no adverse inference can be drawn in case there is sufficient evidence on record prior to 1956
What is the
Hindu
sufficient?
Adoption
You
Act.
see, adoption is not by merely stating that somebody is one's father can be said to be adoption done. Adoption has a procedure,
Yes, Your Lordship.
right?
The procedure has been laid down after 1956. Here the adoption was back in 1949 and
Even-
there is a judgment
just
of
a moment.
1951.
Just a moment. The procedure which has been laid down after whatever you are saying, that procedure was always there in customs. The
Yes.
procedure of adoption is there in customs.
Your Lordship, if I may be permitted to pass on a judgment in which it is clearly said, 1951 judgment, that what is required for the process of adoption, and in cases of old adoption, what may be required and what may be upheld to be valid proof of adoption. That also there is a Orissa High Court judgment clearly on those lines, exactly similar to our case.
We are not here to say and decide as to whether the adoption was duly done, not done. What is important is the person who claims adoption is not there before the court.
Your Ladyship, but the adoption of that particular person has been held valid by this honorable court in SA 635. There is a categorical finding regarding it, Your Ladyship.
Was that the substantial question of law?
In that question, I believe it was, Your Ladyship.
What was the substantial question of law in this case?
Your Ladyship, that is
Which judgment?
the
What was
judgment.
the substantial question of law decided?
Para 5, the substantial questions of law have been stated, Your Ladyship.
Para 5 is the trial court's questions of issues framed.
Yes.
Where is the substantial question of law? The first appellate court's point for consideration. Where is the substantial question of law in this case?
Yes, Your Ladyship.
Yes. What substantial question of law has been decided in the second opinion?
Your Ladyship, if para 19 may be seen, it will answer.
It must be recorded in the judgment itself.
Yes, it has been
Sure.
stated clearly.
Where is
Para
that?
19, Your Ladyship.
Para 19.
Having heard the rival submissions made at the bar and after carefully going through the materials
No.
available in the report,
Second appeal is not decided like this. First, the substantial
we have
question of
talked
law is.
about Gokul
You
Court.
forget about it. I want to know what was the substantial question of law involved in the second appeal. This court does not find any substantial question of law. Just see para 22. The court did not find any substantial question of law to be decided, and the appeal was dismissed without framing the substantial question of law.
It was dismissed, but they have
Yes, and in para 19 they say that you have not joined issues on this. Read para 19.
having heard the rival submissions made at the bar and after carefully going through the materials available in the report, it is pertinent to mention here that there is no specific pleading of the plaintiff
Yes.
that the defendant is not the
So-
adopted
so,
son of Biroja
Pause
Balaji.
here. You are in this particular case. You are joining issues on this as to whether he was the adopted son or not.
But further, they have gone on to discuss
We
this
will not. We
relationship,
do not
saying
know.
that he is the
Maybe
adopted son.
that was not the issue. You did not join issue on this.
Your Worship, I was a defendant in essay number.
We don't bother about it.
Your Worship, but they have held categorically that I am the
Who
adopted
has held?
son. This honorable court.
This honourable court cannot give a finding of fact unless there is a substantial question of law framed by the court in the second appeal. Maybe that so many things are mentioned, and a second appeal is dismissed on not without framing a substantial question of law.
But that was the case.
That was it. So you know second appeal, how is it decided? So merely because some observations have been made, that takes you nowhere. And rather this particular observation of the court that you did not join issue on adoption, this judgment does not help you in any manner. I
Because it
assume that it
clearly
is a
says
detailed judgment. There could be some substantial question of law, But there is a reasoned order not to frame substantial question of law.
Yes, and they had come before this court.
You
On
don't-
basis
we
of
don't
our
bother
argument, it
about
was
that.
dismissed.
That was not the issue before the court.
But
As to whether the adoption was valid or invalid.
I humbly accept your leadership, but here they have said that this honorable court has clearly said that in the addition to besides this, the DW1 in his oral testimony has also stated about adoption of defendant number 1 by Biroja Balabadas. In addition to his oral testimony, the defendants have also proved the school certificate, ration card, and voter list of the defendant number 1 to show that he is the son of Srimati Biroja Baladas and
Is
her
there
husband.
any finding that there was a valid adoption? There may be discussion of many evidences, oral or documentary. Is there any finding that there was a valid adoption? And when the court itself is recording that you did not join issue on that, any observation regarding validity of adoption or it's irrelevant. It's absolutely irrelevant. When you see, it is a case where one party is claiming to be the legal heir and successor, and the other party is claiming right through adoption, and who is certainly not the blood relation, then he will run away from the court, not depose before the court.
I humbly pray that in para 20, this honorable court has held that there is concurrent finding of fact arrived by both courts that defendant number 1 is the adopted son of Biroja Baladas, was not making by ignoring or excluding material relevance or by taking into consideration irrelevant facts, nor the findings of the courts below so outrageously defy the logic as to suffer from the vice of irrationality. So they have held that I was the adopted son, and even on other grounds, your leadership, prior to 1956, a deed
Then
was
at the
not.
you see, the judgment is on the issue where the party joined issue. When the judgment itself is speaking that you did not join issue on that, then any observation, any finding has got no relevance.
Even otherwise, if we see, prior to 1956, prior to enactment of the Hindu Adoption Act, this adoption had taken place,
You
and
see, we are not on the point whether the adoption was valid or not. Our substantial question of law is only whether he was required to be examined.
if no adverse inference can be drawn if a person has not been examined, even that judgment is there. If we have conclusively proved through exhibits and documents marked, then it can be proved that he is the adopted son. Back in 1949, I have been enrolled in a school wherein my father's name is Parvati Kumar Das. The appellant in their cross-examination have accepted that I am the foster son and I was staying with them as their son and being treated as a son.
Just a moment. This document of 1948, there could be a presumption of it being 30 years old document had it been produced from proper custody. Who is producing it? The power of attorney holder. So, is it from proper custody?
Even voter list and ration card we have brought on record.
Voter list and
These-
ration card is not evidence of
There is a judgment which says regarding electoral rolls that until and unless proved otherwise, the electoral roll is presumed to be valid. If they had any doubts regarding this, they should have led evidence. If they had produced regarding fraud, they could have led evidence to that effect, which was never led, your leadership. The electoral roll, which is the records of the government of India, if they are alleging also, one they have never alleged that it is by fraud. If they have alleged by fraud, then they should have brought on record contrary documents to that effect. And old adoption, which is more than 40-50 years old, how will we prove it? We will prove only by leading evidence to that effect. And no adverse inference could have been drawn otherwise.
You read the evidence of PW1.
I do not have a copy of it. I had gone through
So
them.
that's your problem. You don't have problems. The entire case revolves around PW1 and you don't have a problem. And you are arguing the case without going through it.
And I've written the relevant paragraph. मैं सुशांत कुमार मंडल पिता पूर्ण रूप मंडल हिंदू सो एंड सो पूर्वक बयान करता हूँ कि मैं वादी गोकुल चंद्र दास के लीगल कस्टोडियन अटॉर्नी हूँ। पिताजी रजिस्ट्री
लीगली कॉन्स्टिट्यूटेड अटॉर्नी,
कॉन्स्टिट्यूटेड अटॉर्नी हूँ, पिताजी जिसका रजिस्ट्री दलील संख्या सो एंड सो को बनवेर पश्चिम बंगाल एवं रजिस्ट्री ऑफिस में रजिस्ट्री हुआ है, जिसे उक्त गोकुल चंद्र दास ने मुझे मानको जमशेदपुर के समस्त जमीन का अटॉर्नी बनाया है। यह है कि विवादी संपत्ति के बारे में मुझे संपूर्ण ज्ञान है। यह है कि खाता संख्या 776 प्लॉट संख्या 4832 मौजा मानगो वार्ड नंबर 9 में कुल 7 कट्ठा 15 धूर जमीन है, जिसे वादी के पिता स्वर्गीय पार्वती कुमार दास ने विभीषण गोड़ा से रजिस्ट्री दलील द्वारा दिनांक 15/2/1958 एवं 9/4/1959 अपना धर्मपत्नी बिरोजावाला दास के नाम से खरीद करने के बाद मकान बनाकर शांतिपूर्वक दखल करते थे। यह है कि उक्त पार्वती दास तथा उनका उक्त पति का अपना कोई लड़का न होने के कारण उक्त दोनों ने वादों के अनजान वादी को अपना पुत्र के रूप में सन 1948 में सामाजिक रीति रिवाज एवं शास्त्रीय अनुष्ठान एवं वादी को असली माता पिता के उपस्थित में एवं सहमति से दिनांक 14 जनवरी 1948 को
ये कौन इस पर कैसे क्रॉस एग्जामिनेशन? How will this power of attorney will be cross examined on this para 4?
subsequently they brought on report
subsequent event से document से आपका adoption नहीं prove हो जाएगा. How will this particular evidence will be cross examined? Tell us.
there is a judgment which says
Judgment
that
दिखाइए,
patents
please. Show me the judgment. What judgment you are writing? स्कूल वाला डॉक्यूमेंट कौन एग्जिबिट किया?
we had executed.
एग्जिबिट व्हाट? द ओरिजिनल?
नहीं
सीसी कहाँ से?
सर्टिफाइड कॉपी विद ऑब्जेक्शन एग्जिबिट 2
कहाँ से आप इसको लेके आए हैं? सीसी?
Yes. The voter list and ration card also was exhibited.
भाई स्कूल का डॉक्यूमेंट कौन एग्जिबिट कर सकता है? हाउ डू यू गेट the custody of that? How do you get? चोरी करके लेके आए हैं तो सर्टिफाइड कॉपी कौन इशू कर दिया? स्कूल वाले? Do they have the power to issue certified copy? How it will be proved?
Apart from that, voter list and ration card are also on.
Voter list, ration card, Aadhaar.
That is also with objection.
That is also all with the 1948 का आपका ये evidence. How will a person? Every evidence is subject to cross examination. How will anybody cross examine you on this paragraph 4? Explain. Or no cross examination is required because of subsequent events.
Because there are sufficient documents on record to that
Documents
effect,
do
showing
not
that
prove
I am the
adoption.
son of Parvati Kumar Das and Virojawala Das. Any person, if they are asked whose son you are, if an adopted person, either they can show by deed. But in this case, there was no adoption deed because it was prior to 1956 the adoption took place. Apart from that, if any person is asked who is your father or whatever
Your
proof,
conduct is not above board. Where is the plaintiff?
he was sick and therefore.
Where do you say? And how do you say this? That he was
We have
sick and
stated
therefore he
that.
could not have been examined?
We have stated.
Stated means statement से नहीं होगा ना, evidence में दिखाई. ये जितने भी डॉक्यूमेंट्स हैं सबको पब्लिक डॉक्यूमेंट कह के आपने एग्जिबिट करा दिया. All the documents are public document. Certificate, school certificate is also a public document.
We have acquired it from the school. We have stated the lower has held it that he was a public document. Since it was
दत्तक ग्रहण करने के समय क्रॉस एग्जामिनेशन में है, दत्तक ग्रहण करने के समय उपस्थित नहीं था तथा उस समय परिचय भी नहीं, तो क्या क्रॉस एग्जामिन करें?
But the documents cannot be ignored. They have also not brought on record one document or a chit of paper to show
Need not.
or exhibit. They have in fact
Need
admitted that I am
not.
the foster son.
Foster son, you do not,
And
you could be a foster son, but you do not inherit being a foster son. You inherit only if you are an adopted son. You could be foster son. घर में रख लेते हैं लोग, क्या ऐसा बात है? जिसका कोई नहीं है उसको रख लेते हैं.
actions pursuant to that relationship where he has been recorded in the official records as the father.
आपको पता है बिना फादर्स नेम के एडमिशन नहीं होता है at one point of time.
Essentially.
किसी तो बाप का नाम देना ना होगा.
But they have complied with all the requirements of Hindu Adoption Act.
How will you cross-examine a power of attorney? This is what I'm asking. Once you say that all the procedure of adoption has been followed, how do you cross-examine a power of attorney?
Not if there are documents to that effect. I have
Documents, what documents? Just tell us what are the procedure for adoption? There has to be a puja.
Yes, that happened on
Purohit has been examined.
1949 arrangement.
So therefore he could have said that Purohit was there, or this happened, and these people were there, public was there. Purohit is absolutely necessary for Hindu adoption.
There is an exact similar case of the Odisha High Court relation, wherein they have discussed this regarding an old matter. If the adoption is old, then what
Yes.
can be considered?
Sure. You have told us repeatedly that the original plaintiff was sick and therefore he did not come. Kindly show us from any material on record that he was bedridden and therefore he could not have come.
This is a very similar judgment on this point. Paragraph 5 relation. In view of the pleadings of the parties, the crux of the issue is whether defendant number 1 is the adopted son of Loknath. If this is answered in affirmative, then seal of approval has to be fixed to the appellant court's judgment. It is well established principle of law that heavy onus lies upon the person who seeks to displace the natural succession by alleging adoption. When the question arises whether there has been adoption in a particular case, the conduct of parties both before and after adoption, the attendant and antecedent circumstances, the existence of absence of any writing with reference to adoption and any previous adjudication in the matter by the court, though not inter parties, would be relevant. It is not possible in every case to lead oral evidence by giving and taking to prove adoption, and more particularly in the case of old adoption, where the adoption is alleged to have taken place long ago and the adopted son has been treated as such by public documents and by members of the family and other relations. There is a presumption in favor of the adoption, and the burden lies upon the person who challenges such adoption.
Continue reading, please.
In the present case, defendant number 1 claimed to have been adopted by Loknath sometime in the year 1932, and by the time the parties led their evidence in the court below, 45 years had lapsed. It being a case of old adoption, defendant number 1 could not lead ocular evidence regarding giving and taking as required under law. Therefore, he mainly relied upon documentary evidence, mainly electoral roll, Exhibit G2, sale deed, Exhibit A and 6, settlement purchase, statement of Suna, wife of Loknath in a criminal proceeding, Exhibit D and settlement record of right, Exhibit J. On the other hand, the plaintiff, to disprove the alleged adoption, relied upon two
You see, here is
statements.
a case where the defendant was examined.
Your Worship, there's one more judgment which says adverse inference cannot be drawn just because a person has not been examined and there is sufficient documentary proof. Here in this case, because I have brought on record public documents, electoral roll is a public document, the ration card is a public document, school certificate back of the year 1949 is a public document, and the adoption took place 1956 ke pehle. So it is an admitted fact that Parvati Kumar Das and Viroja Bala Das did not have any natural sons. It is an admitted fact that he was staying with them. We have brought on record a statement, proof that 1948 में adoption हुआ, 1949 में हम school में जाके दाखिला करा रहे हैं. So the giving and taking ceremony plus subsequently 1949 का document that my Parvati Kumar Das is my father has been brought on
Where
record
is
by
the
the school
original?
certificate.
You filed certified copy. Who has certified this? Who has issued the certified copy?
School has given us.
No, secondary evidence certified copy is not permissible. You should have produced it. School issue a certified copy.
The fact
Do they have the power to issue certified copies? Can it be admissible in evidence?
Your issue, but how else an old
You
evidence-
could have called for the school headmaster to produce the records. This is how the documents are produced in court.
It is an old document.
Old documents, so what? If certified copy can be issued, then the original can also be issued. You see, the moment you issue a certified copy of a document, it means that the existence of document is not in dispute. Correct? You can't dispute the existence of the document. Then an entry in voter card or ration card. When is the entry made in ration card? Voter card must have been after 18 years after he attained
Yes,
the age of 18.
1975.
1975.
1975 and 1980.
1980.
Two voter
Just a
cards we
minute.
have got.
Two voter cards. What is the time gap?
The case was
48 to 48. Adoption is 48, isn't
Yes.
it? So
two voter cards we have brought on record, that is subset.
that's irrelevant. And when did they die?
77 they died.
So they have not made any declaration that he is my son.
Husband died before
Your
service.
Ladyship, they have brought
No, just a moment. When your entry was made in the voter card or in the in 1980 and 79, at that point of time, the parents had already expired.
no, Your Ladyship. One is for 75. That is prior to the death of the parents. And Your Ladyship, apart from that also, the respondents in the probate case have brought on record a will that they are asking execution of. Now, in that will of the mother, in that particular will, there is a clear statement that I, Gokul Chandra Das, is the son. A document that they have brought on record and are seeking execution of. They are bringing on record and saying that the mother herself has considered and the father have considered me their son and given me the property. So it is a document that they had brought on record. That also shows that I am the son. It shows the intention. It shows the acceptance, which is according to the judgment that I just produced and relied upon by
That document has been exhibited, the will has been exhibited.
No documentary evidence has been produced on behalf of the defendants.
Where is the will?
No, will they have marked in the probate case, Your
No,
Ladyship.
we are not going to mix up probate case with this. And ultimately, if you succeed in the probate case, that the property will lie with you. What's the big deal about it?
Property is already, they have failed the probate case, Your Ladyship.
You see, if there is a probate case for joint ownership, you say that the probate is also in your favor, correct? Jointly in both.
We
in
say
favor
that
of both
the
the
probate itself has been brought on record under suspicious circumstances. They have sought for probate. I have annexed the
So you are-
CC of the
you are-
197.
You are disputing the will also.
Yes, Your Ladyship, but they have brought on record a proof showing that I am the son. I have annexed CC of that particular title suit as annexed Exhibit 8 in the title suit to show that they are bringing themselves a document showing that I am their adopted son. Foster son. Adopted son.
Foster son or adopted son?
Adopted son, Your Ladyship, because in their cross-examination they have said that I was being kept in the house and treated as a son.
What is this cross-examination para 29?
Your Ladyship, it is in this case.
It has been
itself.
mentioned here in the impugned judgment
Of-
that in cross-examination para 29 he has accepted that you are the adopted son. From
That
where
is
do I get this?
Suresh
He's a foster
Chandra
son.
Das.
Yes?
That is Suresh Chandra Das. Sushant Kumar Das
No,
as
you
deposed,
just
the
come to
DW1.
you just come to running page 90. At para 29, he admits that Gokul Chandra Das is foster son of Biroja Bala Das
This has,
and Parvati Kumar Das.
this has been admitted by Sushant Kumar Das. That is the appellate in this case. The DW1 has accepted this.
No, but in the discussion, it is not referring to DW1.
Yes, because
Para
if
five,
if
Same
we-
thing has been referred on page 43 also. Page 43, para 8. DW1 in examination in chief stated in the line of pleading in para 22 of his cross examination he stated that in title suit 1 of 97 and title suit 37 of 93 on behalf of plaintiffs Sushant Kumar Mandal was present and as attorney holder and in both cases he has contested the suit and raised no objection. Further in his cross examination he has admitted that Gokul Chandra Das is the foster son of Parvati Kumar Das and Viroja Bala Das.
that is DW1, Sushant Kumar Das.
This admission takes you nowhere. He only admits that you are the foster son. Foster son will not give you inheritance.
But when
Has the
asked
court
who is a
treated-
foster child,
has
he has
the-
gone ahead and said at para 35 that foster son means the child who is brought up by foster parents but not a natural child.
So, brought up means what? Adopted.
But Your Ladyship, there are evidence to that effect that I was given and taken in 1948. Specific date has been stated. Subsequently, my
Madam,
school
we are not
records.
on the point what is the evidence on record so far as adoption is concerned. We are on the point as to whether the plaintiff was required to be examined on the point of adoption. That is a substantial question of law we are dealing with. The school certificate is exhibit.
Exhibit 2. Exhibit 2.
Para 88 में भी वही बोल रहे हैं. He says that I know the distinction between an adopted son and a foster son. And then he says that as per their parents, they told him that he is the adopted son.
Section 114 of Evidence Act may be seen. In this case, paragraph 11 may be seen.
You just see, this is not the school register which has been exhibited. It is a certificate issued by the school. So, it is not the school register which has been exhibited as Exhibit 2. The principal is issuing a certificate. And what? Where is that record? Where is that record? In the year 1993, they are certifying.
Prior to that,
Who would
1975
exhibit this?
and
No.
1980.
This is not, this is nothing. This is nothing. This is absolutely scrap of paper. This will not show adoption. They should have produced the school register, the entry. That could have been of some value. This certificate issued in the year in 1993.
But subsequently,
That to a
even-
private school. And you say it's a public document.
but there's no allegation by them.
Need
saying
not
that-
be. You claim adoption, you have to prove adoption. Need not be any allegation to this. It has been marked with protection. And he has been admitted in the school by his father, Shri P.K. Das. This is the name of the father. How many P.K. Das do you know?
In this matter, it is Parvati Kumar Das.
How do you assume? How do you assume?
Because Your Ladyship, in their statements, they have said that I am son of some Denugri Das. It has come on record.
Who has to prove, madam? This is absolutely basic.
Ladyship,
You are the plaintiff, you have to prove.
yes.
This P.K. Das, how do you correlate to Parvati Kumar Das? P.K. Das means what?
Your Ladyship,
You have a number of P.K. Das in Jharkhand High Court also. Then?
Your Ladyship, my only contention here is that no adverse inference could have been drawn just because he was not examined. Because contrary to that,
That
we
is
have-
what I have to decide.
there's
that is
one
why so many
judgment
questions
that
to
I
you.
want to bring on record, Your Ladyship. Para 11. Para 11.
Yes.
In our opinion, the question of drawing an adverse inference against Apte and Bavdekar on account of
You
their
just
absence
please
from
don't
the
read the
court.
just like that. You just read the facts of the case.
Facts.
Yes.
The present appeal by special leave arises out of an execution proceeding and is directed against the judgment of High Court of Bombay in letters patent appeal, setting aside the order of single judge in second appeal. The appeal came up for hearing on 24th of September 1981. After the conclusion of the arguments of the counsel of the parties, we allowed the appeal with cost, set aside. The appeal was allowed with costs, set aside of the judgment of the High Court, and restored that a district judge for reason to be recorded in the following terms. This appeal is allowed with cost of this court, and decree passed by the district judges restored. Reasons will later follow on. Respondent number 1, Ramchandra Gangadhar Ashtekar, since dead, filed a regular suit for recovery of his dues from Kamla Pictures, of which Bapu Saheb Narayanram Mohit was the sole proprietor. It appears that after filing the suit, the plaintiff applied for attachment of the defendant's properties before judgment under Order 38, Rule 5 of CPC, and the following properties were attached. The actual possession of the defendant's aforesaid properties was with Panduranga Jiva Raoji Apte, the appellant, at the time of attachment. The suit was eventually decreed for a sum of ₹9,000 and odd with interest and costs. The said attachment was continued by the decree. The decree holder sought to execute the decree by sale of the property attached. As stated earlier, the property was in possession of Apte, the appellant. The decree holder therefore prayed that Apte should be called upon to produce the property in court and the same should be sold. Notice was issued to Apte, the garnishee, who appeared and filed written statement. He took up the proof that property had already been pledged with him by judgment debtor for his debt, and the attachment levied at the instance of the decree holder was subject to his encumbrance on the property. He also alleged that he had raised his contention in the suit itself at the time of attachment before judgment, and he was allowed by the court to sell the property pledged with him. Accordingly, he exercised his right under Section 176 of Contract Act and sold the property to one Madhusudan Vasudev Bavdekar after due notice to the judgment debtor, as also after a public notice. But the proceeds of the same were not sufficient even to satisfy his own debt. Under the circumstances, he was not in a position to produce the property in court. In view of the stand taken by the appellant,
Yes, I've got the facts. You just read the paragraph.
Para 11. In our opinion, the question of drawing an adverse inference against Apte and Bavdekar on account of their absence from the court would raise only when there was no other evidence on record on that point in issue. The first appellate court had relied upon the admission of the decree holder himself, and normally there could be no other proof than the admission of the party. The High Court, however, has observed in the judgment that the decree holder has made no admission in his evidence which would justify refusal to draw adverse inference for the failure of Apte and Bavdekar to step into the.
That's right. Where is the admission?
Your Worship, they have said that they say it was foster son. Next line they say foster son means who is staying without, but is not a natural born son. That is what they have explained as foster son.
No, that is not correct. You read paragraph number 88 of the cross examination. Para 88 of the cross examination. पढ़ के सुनाते हैं। दत्तक पुत्र तथा पालिश पुत्र का मतलब मुझे ज्ञात है। गोद लिया गया पुत्र दत्तक पुत्र है, जबकि पालित पुत्र लालन पालन किया गया। He is very much aware what is the difference between दत्तक पुत्र and पालिश।
35 he says that.
और 88 नहीं पढ़ी, पढ़ी दिखाई हमको पढ़ने के लिए।
Page 89 he says Gokul Chandra दास के माता पिता के कथानुसार गोकुल चंद्र दास बिरोजावाला दास एवं उनके पति के पुत्र हैं, ब्रैकेट में दत्तक।
उनके माता पिता के कहे अनुसार।
हाँ,
तो आखिर ये जो दत्तक पुत्र खुद हैं, उनका क्रॉस एग्जामिनेशन नहीं होगा तो क्या होगा?
So parents had died in 77. Power of
पेरेंट्स
attorney came
77
in.
में डेथ हो गया।
Power of attorney came in light in 1988. So how could he have conversed with them?
but he had known the family from 62, which is also an admitted fact. Your Worship, he says कि both गोकुल चंद्र दास के माता पिता के कथानुसार गोकुल चंद्र दास बिरोजा बाला दास एवं उनके पति के पुत्र हैं दत्तक। बिरोजा बाला दास इज द मदर और उनके पति पार्वती कुमार दास।
और जो एडॉप्टेड सन है उनका क्रॉस एग्जामिनेशन का कोई जरूरत नहीं।
Your Worship, but up till the High Court, it has been held that he is the adopted son.
It has not been held.
With the judgment 6
We'll
SA
deal with
635.
And what is the exhibit of power of attorney?
Exhibit 5.
Exhibit?
Exhibit
Fine.
5.
The reason is that he has left the place and has gone to West Bengal.
And he was sick.
From where he with us.
They were staying. Your Leadership, para 5 itself of the appellate court judgment. Witnesses were examined after framing of issues and on behalf of
Madam,
plaintiff.
you show it from the evidence. Appellate court, once that appeal is admitted on substantial question of law, everything is under cloud. You show it from the evidence that he was seen.
When it may be passed over, I will.
Look at the evidence. Maybe that power of attorney has been, during cross-examination, he has been asked as to why the plaintiff is not coming.
There is, Your Leadership, and in fact it has been discussed that he has supported the case. There is a lengthy cross-examination that why the original plaintiff has not come before the court to examine himself, and the witness has stated with regard to health condition of the original plaintiff. There is an entire cross-examination where it has come that his
Show me
health.
those paragraphs.
Yes.
Any particular judgment you want to refer to?
It's
It's
regarding
STW.
power of attorney and already.
STW.
Yes, Lordship.
In which paragraph? Any particular paragraph?
Para 13.
Para?
Yes, Lordship. Para 13.
1, 3.
May I read, Lordship?
Yes.
It is settled legal proposition that the power of attorney holder cannot depose in place of the principal. Provisions of Order 3, Rules 1 and 2 CPC empower the holder of the power of attorney to act on behalf of the principal. The word acts employed therein is confined only to acts done by the power of attorney holder in exercise of the power granted to him by virtue of the instrument. The term acts would not include deposing in place and instead of the principal. In other words, if the power of attorney has preferred any acts in pursuance to the power of attorney, he may depose for the principal in respect of such acts, but he cannot depose for the principal for acts done by the principal and not by him. Similarly, he cannot depose for the principal in respect of matter as regards which only the principal can have personal knowledge and in respect of which the principal is entitled to be cross-examined. Lordship, in the second appeal 631 of 15 that was being referred, para 20 continuing lines, Lordship, why the power of attorney was held valid in that case. Here the defendant number 2 is not only the power of attorney holder who is authorized to pursue the suit on behalf of the defendant, but he is himself a party in the individual capacity as defendant number 2, because the sale deeds were executed by him in his favor and in his wife's favor. Hence it was termed valid, but not in this case. Lordship.
Further, it may be read, Your Leadership. Otherwise, also in the absence of any specific plea of plaintiff that the defendant number 1 is not the adopted son of Viroja Baladas, and also considering the documentary evidence available on record, this court is of the considered view that concurrent finding of facts arrived by both the courts below to the effect that the defendant number 1 is the adopted son of Srimati Viroja Baladas was not made by ignoring or excluding relevant materials or by taking into consideration irrelevant materials, nor the finding of the courts below so outrageously defies the logic as to suffer from the vice of irrationality, incurring the blame of being perverse. There is no scope for this court to interfere.
Even incorrect finding of fact does not become a substantial question.
They have not gone on appeal against this.
Need not.
And the fact that I have been held to be the son, adopted son, holds good. I will refer to the.
वो जजमेंट भी लेके आएंगे that the issues, what the court decides is the issue between the parties, because that was not the, you did not join issue as to whether there was the adopted son. So therefore mere observation or finding of the court that he was the adopted son has no relevance. ये judgment कौन लेके आए? आप लेके आए? सर से कुछ चीज़ बता देंगे। सर ये जो सेकेंड अपील ये जो साइड कर रहे हैं उसमें ये बोल रहे हैं कि they did not join issue as to whether there was adopted son or not an adopted son, but still the court says that it is he was the adopted son. So that is not a finding of the court because they did not join issue on that.
Yes,
So कोई judgment
it
लेके
is not binding. Then the matter is different for ejectment of the defendant. And how can a power of attorney holder, holding power of attorney since 1988, can say about 1958?
That he has argued.
That
सेकेंड हाफ में आइए, लिखाएंगे आज ही, जो लेके आना है ले आइए.
But it should be posted tomorrow. Whatever are the relevant paragraphs, I will mark and I will show it to the board.
Okay. लिखिए. The learned counsel for the parties have advanced their arguments at the instance of the learned counsel for the respondent. This matter is directed to be posted tomorrow. कल 10:30 बजे पाठक करके रखेंगे तो पहला हो जाएगा बस. Who wants to place the evidence of PW1? Post tomorrow. Matter is treated as part. ये उसी में
Assault case item 1, second April 65 of 2016.
But the opponent is plaintiff. It was dismissed. Appeal court has also performed. When order number 16, dated 13th of last week, 2024. Following substantial questions of law. The appeal is admitted and will be heard on the substantial questions. The first court of fact failed to consider and record its independent with respect to oral and documentary evidence adduced on behalf of the plaintiff and the adversary and other evidences of action on the plaintiffs of the suit. Whereas the first appellate court has failed to return a finding with respect to item number 2, 3, 4, 6, 9, 10 of schedule A, which was not claimed particular. These are only two situations.
What is the consequence of abatement against respondent number 18? What is the legal consequence? Wife of Dileshwar Mehta.
Respondent number 8,
Respondent number 18.
Chaturmukhi.
No, respondent number 18 is Basanti Devi, wife of Dileshwar Mehta. What is the consequence?
She is the plaintiff and the performer respondent.
She's just a performance. All right. Let us see the judgments.
First thing which I would like to point out that about the land in question for which this suit here is to check is the Mundari Tidari land. These lands have not been listed in the court. And still, the Mundas are the landlord. And till today, the Rayats whom they pay rent to the Munda. This fact has been
No,
taken.
this is the land is Mundari Kutkatidari land,
It has not vested in.
not vested in state.
So still the landlord is Munda. The rent receipts are issued by the Munda itself, the landlord. That's what I want to point out. It is not in dispute also. Both the parties are claiming suit property by virtue of Hukumnama and the rent receipts granted by the ex or the landlord, not ex. Parties are litigating
Yes,
some
sir.
since long.
Hukumnama and issuance of rent receipts. Sada Hukumnama?
Yes, it is not. Both the parties.
Plaintiff is claiming, give the details of the plaintiff regarding Hukumnama and rent receipt.
The defendant first.
Give the plaintiff first and then defendant.
Yes.
It was a title suit.
It will be title. Parties you are listening to.
I just made a column, comparative column. Give me the Hukumnama date for plaintiff.
Cooperative columns I have not made. But
I'm just making it. You just give me the details of the plaintiff.
let
Hukumnama, date of Hukumnama, and exhibit number.
in the plan which is given. My reference I have written. Schedule A property. It is schedule.
There is only one schedule,
Yes, but it contains 14 items.
49,
14 items.
49 names,
14 items of
14 items. Okay, no problem. But Hukumnama is in connection with all the properties or it is?
Yes.
I just want to know the date of Hukumnama of the plaintiff
Yes.
and issued by whom and in whose favor.
Yes. It is not for the item number 1. It is not 25th of August 1969.
And defendant?
It is exhibit 6 by C.
6 by C. 25/8 or 25/12. 12 की 8,
25
25/8, 1969.
69. खैर इक्कीस से 25 बस पेंसिल से लिखा है लिखना लगता है 25 और आइटम नंबर 2, 3, 4, 5, 6 ये सभी एग्जिबिट 6 बाई ए से हुक्मनामा से हैं
डेट बताइए।
डेट जी
Date
12th of February 1960
1960.
6
60. Exhibit A.
12th of February 1960 16/2/7
Exhibit 6 by A.
it is 6 में
This is another Hukumnama.
हाँ इसमें 2 से लेकर
6.
फिर नहीं और ये
7 से
ये 10 तक
7 to 10.
7, 8, 9 और 10 6
इसका हुक्मनामा
ये इसी का सब 6 में है
तो 2 to 14.
2 to 10
2 to 10. 42 to 10 or 11 to 14.
11 जो है और 12 ये 6/D
11 and 12.
इसका डेट है 19/11/61
19/11/61 6/D
1911-1965
6/D
6/D
and 13/14.
और 13 नंबर जो है वो 6/D
डेट बताइए.
तो डेट इसका 15/4/60
और 14 नंबर
14 नंबर 6/D
6/6/E. इनका जरा वो माइक ऑन कर दो. इसका डेट बताइए.
6/E
डेट
Date is 9th of March 1970.
9/3
9th March 1970.
1973. Correct?
73.
73.
Yeah.
इनको आप already करते हैं.
Correction has
73.
led
73.
70.
The learned counsel for the appellant has submitted that it is not in dispute that the property involved in this case is Mundari Kutkattidari land, which did not vest in the state upon abolition of zamindari.
Before that, one more fact is required.
He also submits that the landlord is Munda and not the state, and therefore hukumnama as well as the rent receipts are issued by the landlord who are Mundas. The plaintiff, the Schedule A of the property, which is also the suit property, consists of altogether 14 items. Item number 1 is covered by Sada Hukumnama dated 25/8/1969 within bracket Exhibit 6/C. Item number 2 to 10 is covered by Sada Hukumnama dated 12/2/1960 within bracket Exhibit 6/A. Item number 11 and 12 is covered by Sada Hukumnama dated 19/11/1961 within bracket 6/D. Item 13 is covered by Sada Hukumnama dated 15/4/1960 within bracket Exhibit 6/B before Bombay. Item 14 is covered by Sada Hukumnama dated 9/3/1973 within bracket Exhibit 6/E.
9th May.
9th May 9/5/73.
But the facts of the case you will see there.
डिफेंडेंट का बता दीजिए साथ साथ.
बस इसको थोड़ा सा एक लाइन में बता. ये 1939 से ही ये सब लैंड में पोजीशन में थे और बोर्ड कार्ड वगैरह जो उसमें अलाउड है उसके हिसाब से इन्होंने जब किया तो फिर लैंडलॉर्ड ने ये सब डेट्स में इसको हुकुमनामा से भी सेटल किया.
The learned counsel has also submitted that the plaintiffs were in possession of the suit property right from 1939.
Yes.
1939, and when they developed the suit property and made it cultivable
40 to 46.
during the period from 1940 to 46, the landlord within bracket Munda bracket goes
Just with respect to schedule 1 to 10, which was required by virtue of Hukumnama 6A, it was 39 to 45. Possession and reclamation 19 to 45. 1939 to between 1939 to 1945. With respect to the land, another land, it is 40 to 45, 46. Two dates are.
ऐसे फिर से लिखिएगा इसको. The learned counsel further submits that the property with respect to item number 1 to 10 was in possession of the plaintiff since 1939, which they developed it till the year 1945 and made it cultivable and remained in possession, and ultimately the landlord settled the properties in the aforesaid manner through Sada Hukumnama. With respect to property from item number 11 to 14, it has been submitted that the plaintiffs were in possession since 1940 and they developed it till 1946 and made the land cultivable, and ultimately the said property and remained in possession, which were also settled in their name by aforesaid Hukumnamas. Rent receipt कब से है?
So far as regard the property, your lordship, for which a substantial question of law has already been.
नहीं अभी ये कहानी खत्म नहीं हुई. रेंट रिसीट आपका कब से?
Tenancy.
रेंट रिसीट आपके पास
Rent receipts like continuous.
नहीं, कब से है? ओल्डेस्ट, क्योंकि हर एक का अलग अलग होगा.
लेकिन हुक्मनामा ग्रांट होने के बाद का है.
ग्रांट होने के बाद का है.
पहले का है.
पहले का तो
हाँ,
होगा ही
हो
नहीं,
भी
हो भी नहीं सकता है. इट इज इम्पॉसिबल
लेकिन
बिकॉज
जैसे 60 का है तो 67 में मिला है, इस तरह से थोड़ा डिले. तो अभी डेट नहीं बता.
69 का सबसे ओल्डेस्ट रेंट रिसीट कब का है?
बासठ
62 का कौन सा वाला हुक्मनामा?
60 वाला
60 वाला.
60 का भी
60 का भी 1962 का है.
60 का भी एक डेट लिखा है. 16/12/60 फरवरी 2060 का लिखा है. इमीडिएटली ही मांग रहे हैं.
1960 और
उसके बाद 65 का भी
61 वाला.
66 का भी 66 का भी.
देखिए आपके पास दो हुक्मनामा है. आपका क्वेश्चन ऑफ लॉ ऐसा बना हुआ है कि अलग अलग लॉट का अलग अलग फाइंडिंग देना, तो आपको अलग अलग लॉट का ओल्डेस्ट रेंट रिसीट तो बताना पड़ेगा ना. इसके बिना तो नहीं होगा. तो कौन सा पीरियड का कैसे?
उसका डिटेल्स जो है ट्रायल कोर्ट ने जरूर कंसीडर किया है, लेकिन एपेलेट कोर्ट का कोई कंसिडरेशन इस पॉइंट पर नहीं. एक जनरल कंसिडरेशन करके ऑर्डर नहीं किया, और इसीलिए वैसा सब्सटेंशियल क्वेश्चन ऑफ लॉ बना कि आपको ओरल एविडेंस तो बिल्कुल भी कंसीडर उन्होंने नहीं किया, और जो दूसरा एविडेंस भी कंसीडर किया है, जैसे हम लोगों का पहले इसमें बहुत दोनों पार्टीज का लिटिगेशन हुआ. 144 के प्रोसीडिंग हुए थे, उसके बाद 145 के भी प्रोसीडिंग में मेरा पोजीशन डिक्लेयर हो गया था विद रिस्पेक्ट टू शेड्यूल बी. इसके बाद ये मामला जो है सो हाईकोर्ट आया, फिर हाईकोर्ट ने उसे सेटिस्फाइड किया, फिर कहा कि आप फ्रेश प्रोसीडिंग आप चला सकते हैं. तो फ्रेश प्रोसीडिंग जब चली तो 4 केसेस विद रिस्पेक्ट टू जो कि स्पेसिफिकली डिफाइंड इन शेड्यूल बी, उसका वो 4 केसेस चले, और अल्टीमेटली कोर्ट ने भी उसे ड्रॉप कर दिया कि मैटर पर्टेन्स टू स्टैट. उसके बाद ही छूट आया. और ये हुजूर का जो सवाल है वो भी इस केस में बार बार आता रहा है कि स्पेसिफिक नहीं है, और बहुत वेल डिस्क्राइब नहीं है. ऑर्डर 7 रूल 3 के हिसाब से 4 के हिसाब से इसमें डिस्क्रिप्शन प्रॉपर होना चाहिए. देयर इज ओनली 2 बाउंड्री in some of the properties. My lord will find there is only 2 boundaries. In some of the property there are 4 boundaries. The learned trial court has also said how the property will be identified. whether it can be identified or not. So these were the natures of pleadings and these were the natures.
So the appellate court has reversed the decree.
Yeah, no, it has affirmed, but so no discussion with respect to our evidences. So even my lord will find that it has come in the trial court judgment that their evidences also they have admitted that we are in possession, though they say that we are in some part of the possession. And the trial court has also said. So far as whether I am in possession or I am not at all in possession, if there are some evidences on it, but that is required to be discussed by the appellate. So that was one of the reasons that such a question of law was framed. Second one, there are several items which now the defendants are not claiming. If they have no claim over those lands, how this can be dismissed? That is also a question.
Which all items covered? They are not claiming.
They are not claiming, then at least.
Which items they are not claiming? There are 14 items. Which items they are not claiming?
Item number 2, 3, 4, 6, 9, and 10.
Item number 2, 3, 4, 6, 9,
9 and
10.
How should you claim?
Defendants have no claim.
No. उसको तो कम से कम डिसमिस नहीं कर सकते थे
और इसमें आपका पोजीशन है
हमारा
Mr. Sani, you need to verify this.
Or otherwise I agree.
Defendant number 2, 3, 4, 6, 9, 10. They say that defendants have no claim.
The admission on the part of the defendant will not be
So that is a separate thing.
sufficient. Therefore, not the learned trial court took pain, which my learned friend rightly said, that each and every hukumnama, rent receipt, everything has been discussed by the learned trial court in details.
But the appellate court
And
has not done
ultimately
anything.
it was found that the plaintiff has failed to prove his case and establish his title over the land in question. If it is the plaintiff which is deciding factor, it is not for the defendant, and the onus will not shift to the defendant to prove his own case. So it is the plaintiff who has to stand on his own leg, and that the learned, both the courts have recorded the finding that the plaintiff failed to prove their case. If Lordship may kindly permit me, I will only refer only one sentence. After discussion in details, subject to Lordship's kind pleasure. So far, my Lord, my learned friend already submitted the hukumnamas furnished by the plaintiff. My learned friend kept silent over the hukumnamas filed by
अभी तक
the.
वहाँ पहुँचे नहीं.
तो हम मुझे उसको पूरा कर देते हैं.
अभी तक वो जर्नी पूरी नहीं हुई.
Exhibit H to
That is not
H10.
intentional, not at all.
आप बताइए. अभी तक हम लोग वहाँ पहुँचे ही नहीं. हमको लगा कि आपसे हम
नहीं इनको बोल रहे
पूछें.
हैं डोंट टेक इट अदरवाइज हम भी रहते तो हम भी यही करेंगे. H to H by 10.
H to H by 10 is your
H
book
series,
now.
H series, followed by rent receipts. Those are Miller exhibit B, C, D to D by 4, E to E by 2. These are the rent receipts. Your Lordship may kindly see the trial court judgment. I will not take much more time. Trial court judgment.
Appellate court में पेज 5 में तो लिखा ही है.
हाँ वो सब डिटेल में दिया है, ट्रायल कोर्ट भी लिखा है, लेकिन मेरा कहना है हुजूर कि वो तो डॉक्यूमेंट्स कौन क्या दिए उसके बारे में बोलो. अब जो डिस्कशन जो है लर्नड मुंसिफ का ट्रायल कोर्ट का, इफ लॉर्डशिप में काइंडली कम टू मिलर पेज नंबर
उनका हुक्मनामा exhibit H.
एच सीरीज वही तो
H series.
एच सीरीज बता दीजिए, हम अगर गलती करें तो जरूर बता दीजिए. ये लॉर्डशिप जस्ट सी मिलर पैरा 23 इनर पेज 10 ट्रायल कोर्ट जज, वहाँ से हुजूर डिस्कशन, वहाँ से डिस्कशन है जिससे मेरा लर्नड फ्रेंड जरूर पढ़े हैं कि इस प्रकार आइटम नंबर 2, 3, 4, 6, 9 और 10 से संबंध में प्रतिवादी गण का कोई दावा नहीं है जो पढ़े, और विवाद केवल आइटम नंबर 1, 5, 7, 8 और आइटम नंबर 11 से 14 की भूमि के लिए है. ये तो ठीक पढ़ा है. अब जो थोड़ा सा आगे अगर पढ़ते हैं, आई एम जस्ट स्कीपिंग फॉर 2 पेजेस 3 पेजेस rather. The losses just come to after minute discussion with regard to each of the documents and each of the oral witnesses whose evidence has been discussed by the learned trial court. Para 27. Para 27. That is at page 17. At page 17. Para 27. वादी की ओर से अन्य दस्तावेजों में प्रदर्शित एक बात नंबर सचन सच का आदेश पारित प्रतिलिपि जिसका 145 की कार्रवाई में प्रसंगत भूमि स्वास्थ्य से संबंधित होना पाया गया है। प्रदर्श 3 में पारित आदेश के मामला उच्च न्यायालय में रीट याचिका प्रस्तुत हुई थी जिसके आधार पर 145 की पूरी कार्रवाई को पास कर दिया गया। जो इनके पोजीशन डिक्लेयर हुआ था वो पास हो गया, इसलिए प्रदर्श 3 का कोई भी विधिक मूल्य नहीं। मुझे बोले कि मेरा पोजीशन है तो हाईकोर्ट ने उसको पास कर दिया। अब मुझे पैरा 29 पढ़ा है। पैरा 29 उभय पक्ष की ओर से प्रस्तुत
ये जो आप पढ़े कहाँ क्वाश कहाँ लिखे हैं?
अपास मीन्स सेट असाइड।
अच्छा,
इन हिंदी में हुजूर अपास का मतलब सेट असाइड। शायद अगर गलत नहीं बोल रहा
हम तो पहले ही बोले परसुएंट देयर टू सिविल
तो हुजूर हो गया खत्म,
तो
पोजीशन वाला
खत्म।
अब पैरा 29 उभय पक्ष की ओर से प्रस्तुत किए गए साक्ष्यों में से यह पाता हूँ कि विवादित प्लॉट 688 चूंकि बड़ा प्लॉट है और उस प्लॉट के संदर्भ में पक्षों की ओर से दाखिल किए गए हुक्मनामों में कुछ भूमि की चौहद्दी में वादी एवं प्रतिवादियों का निज अंकित है। प्रतिवादी की ओर से परीक्षित साक्ष्यों के साक्ष्य संख्या 10 ने अपने प्रतिवादी गण की पंडिका 12 में यह कहा है कि वह नहीं जानता है कि पहले कौन हुक्मनामा लिया और कौन बाद में। प्रतिवादी साक्षी संख्या 9 ने प्रतिपरीक्षण के पंडिका 13 में कहा है कि ग्राम सेवक बड़काटान की जमीन के नीचे धान आबाद करता है। हाँ। प्रतिवादी संख्या 6 संपत्ति देवी ने अपने लिखित बयान में अपनी जमीन के पूरब वादी का खेती करना कहा। प्रतिवादी सच्चा संख्या 3 तो राय मुंडा मछुआ ने विवादित मंडल में दक्षिण में रामसेवक का भी होना कहा है। इसी प्रकार वादी की ओर से दाखिल हुक्मनामा 6/D और 6/B में उत्तर और पूरब सीराम महतो का दून और टाण अंकित है। पदस 6/D एंड 6/B 1960 61 थे, जबकि सीराम महतो के पक्ष में निष्पादित हुक्मनामा 1932 और 1945 है। पदस संख्या 6/B में नहर के बगल में सीराम की जमीन होना अंकित है, जिससे यह स्पष्ट है कि विवादित प्लॉट में अंदर प्रतिवादी का भी जमीन है जिस पर ये लोग दखल में हैं। किंतु अभिलेख पर उपलब्ध साक्ष्य में वादीगण इस विषय को साबित करने में सफल नहीं हुए कि वाद पत्र के अंदर में दर्शित अनुसूची की भूमि पर ही उनका दखल और कब्जा है, बल्कि वादीगण ने वाद पत्र की अनुसूची ए में दर्शित चौहद्दी को भी जो भूमि अंकित किया गया है वह
उसे स्वयं जानकारी नहीं।
स्वयं की जानकारी, भूमि की स्वयं जानकारी नहीं। इसी वादीगण ने अनुसूची ए के संपत्ति पर अपना वैध स्वतः हित और अधिकार होने का दावा सादे हुक्मनामा के आधार पर किया है। सादे हुक्मनामा में पदस संख्या 6 में वर्णित संपत्ति का इस बात की अनुसूची ए के आइटम नंबर 1 से 14 में सम्मिलित नहीं है। इसी प्रदर्श 6/A में केवल 2 चौहद्दी अंकित है तथा वादीगण ने इन हुक्मनामा से संबंधित भूमि को अनुसूची ए के आइटम नंबर 2 से 10 में दर्शित किया है। उसमें भी उसे केवल 2 ही चौहद्दी दिया है। अभिलेख पर ऐसा भी कोई साक्ष्य नहीं है कि आइटम संख्या 2 से 10 की भूमि पर प्लॉट की भूमि पर है। आइटम संख्या 2 से आइटम नंबर 10 की भूमि बिना चारों तरफ का वर्तमान चौहद्दी के स्थल पर निरीक्षण नहीं हो सकती है।
निश्चित नहीं,
हाँ, निश्चित नहीं,
आइडेंटिफाइबल नहीं है।
आइडेंटिफाइबल वादी संख्या 6A के आधार पर सत्य की घोषणा नहीं की जा सकती। 6/B, 6/C, 6/E प्लॉट नंबर 688 से संबंधित है, जो स्वीकृत रूप से 98 एकड़ क्षेत्रफल का है। मौखिक साक्ष्य से यह विषय स्थापित हो चुका है कि इनसे कम कम से कम जमीन नाम की जमीन है, तीन नाम की जमीन है। वादीगण का दावा इन तीनों को जमीन पर है। इन जमीनों के वादीगण बड़का टान जमीन पर अपना दावा यह कहकर कर रहे हैं कि बड़का टान की जमीन में उनके सभी जमीन सटी है। किंतु आइटम नंबर 1, 8 और 14 की चौहद्दी के मिलान से यह स्पष्ट होता है कि ये तीनों जमीन स्थान पर आपस में सटा हुआ नहीं सकती है। जमीन के विषय में वादीगण का पद 6/T में सुमेजित नहीं है। वादीगण इस विषय पर स्थापित करने में विफल रहे कि अनुसूची ए के संबंधित पर इनका दखल वर्ष 1935 से आया, बल्कि मौखिक साक्ष्य के वादीगण के बाद संपत्ति से अधिक 10 से 12 वर्ष पूर्व दोनों में परिवर्तित करना पड़ा कहा। वादीगण की ओर से दाखिल की गई जमींदारी रसीद हुकुमनामा निष्पादन के तिथि के नहीं है। पदस 5 सीरीज में से जो मामले की पदस 6/A शासनसाज पदस 5 सीरीज 1965, 1969, 1973 की है, जो निष्पादन 1960 से होगा, तो जबकि स्थानीय रसीद संख्या शासनसाज में जारी नहीं होना अंकित है। पदस संख्या शासनसाज साथ ही रसीदों के प्लॉट नंबर भी नहीं है तथा न ही रसीदों का स्वत का माना जा सकता है। अतः उपरोक्त विवेचना के आधार पर मैं यह पाता हूँ कि यद्यपि कि प्लॉट संख्या 688 की भूमि पर वह कुछ न कुछ भूमि पर कब्जे में है, किंतु वादीगण इस विषय को स्थापित करने में सफल नहीं हुए हैं कि उनका प्लॉट संख्या 688 भूमि में कहाँ पर, जो बात पत्र के आइटम अनुसूची ए में उन्होंने जो दर्शाते हैं कि वादीगण इस विषय में विफल रहे हैं। अनुसूची संख्या 1 को उन्होंने 1935 से 45 के बीच में बताया था, तो जो वादीगण इस विषय को भी स्पष्ट नहीं कर सके कि 5 की उन्होंने वर्ष 1945-46 में तोड़कर बनाया है और दखलकार हैं, तो 1967, 69 और 73 में अलग अलग हुकुमनामा में क्यों निर्गत हो, और इन हुकुमनामा को बढ़नी चौहद्दी में कम से कम 2 हुकुमनामा की चौहद्दी में वादीगण की जमीन 2 तरफ क्यों नहीं लिखा गया। वादीगण ने जब बड़का टाट के 4 बार में 4 टुकड़े जमीन बंदोबस्ती करना कहा है, इस बीच में पड़ने वाले 2 टुकड़ों को 2 तरफ वादीगण का जमीन दोनों होना चाहिए था। इस प्रकार वादीगण यह विषय स्थापित करने में भी विफल रहे कि अनुसूची ए के दर्शित संपत्ति उनके द्वारा दाखिल हुकुमनामों से These are the background of finding.
So they did not
This is purely a
succeed to prove their case.
They failed to prove their case.
And which is the reason for the appellate court also to say
And
that
the appellate court has not reversed. It has confirmed and concurred the findings of the trial court, who has taken pain to discuss each and every document, each and every witness. So these are findings of fact. Your Lordship may kindly see, ultimate finding is para 34. Now Your Lordship just see the appellate court judgment. Your Lordship may kindly see paragraph 10 onwards, the finding starts. Para 10, heard the parties such and such, description of the document. Para 12, Miller. Para 12, the suit land is Kunkati Zamindari land. Then the description of the property. Then Miller, Your Lordship may kindly see page 7. The learned court below has considered, 5th line from top, page 7, towards middle Miller. The learned court below has considered Exhibit 6 beyond the description of land. There is some distance regarding Exhibit 6 by B and 6 by C also. these exhibits do not match with the items mentioned in schedule of the plaintiff. But the learned trial court has held. Only two boundaries have been given in the Hukumnama, but the learned advocate of the respondent submitted that only two boundaries have been mentioned because Khatian has been biased only two boundaries. The dispute between the parties is regarding the entire land, but the plaintiff has stated that the proceeding was initiated regarding the land mentioned in Schedule B, not in for A of the plaintiff. The appellant plaintiff filed title suit being aggrieved by the learned executive magistrate, whereby the proceeding 145 CRPC was dropped against the defendant. Both the parties have filed Sada Hukumnama. Then Order 7 Rule 3, description of the property. This is the main issue. And the learned trial court has discussed each and every document. Para 13, after quoting where the subject matter of the suit is immovable property, the plaintiff shall contain description of the property sufficient to identify, and in case such property can be identified by boundaries or numbers in record of settlement of survey, the plaintiff shall specify such boundaries or numbers. As per section 44 of the CNT Act, the rayat is entitled to the rayat shall be entitled to receive from his landlord a lease containing the following particulars, namely such and such. What are the requirements under the law for Hukumnama? That has been quoted. Then, following Madras High Court judgment, then your lordship just turn to the next page. The settled principle of law is that where out of two claimants neither appears to be in actual possession, the one who has the title is held to be in possession for possession follows. But if neither has title, then the one who first enters, if his possession is continuous, is entitled to the possession as against the other. The Hukumnama of the respondents begins from 1932, and I am of the view that when the landlord has once exercised his option and treated the person as tenant, he cannot subsequently clear him as a trespasser. The learned counsel for the appellant has filed certified copy of R.S. Khatian. Then after discussion of Khatian, last part, the statement of PW3 such and such, the plaintiff number 2 Govind Mahato has deposed in the year 1956. He was a student of class 4 and he has stated his age about 58 years in 2007 and he has reclaimed the land during 1939 and 245. These facts create doubt over the claim of the plaintiff appellant and accordingly the findings of the learned court below does not want any interference. It appears that the suit is held by such and such. So it is in addition. Of course, this language was not used by the learned trial court, but practically in sum and substance, he also stated categorically after discussing each and every document that the plaintiff failed to pinpoint the land and prove his title on the basis of Hukumnama coupled with the so-called rent receipt. The person who didn't bond, he converted the land as a corporate. That has been found. So these are the findings of facts. I can understand if the trial court degree was in their favor. The learned appellate court did not discuss everything and reverse the degree. Then one can understand that it is necessary. But when the learned trial court has framed the issues, the learned appellate court also framed the issues, discussed the issues, and relied upon, he did not disagree with the trial court. He also recorded the reasons why he did not disagree. So my humble submission.
Would have made any difference in the findings? Which is that evidence which would have made some difference in the finding? Either you show me some evidence that would have made some difference, or otherwise there are concurrent findings, need not be a very detailed judgment. We have to see substantial compliance of Order 41.
I agree. What I want to say, that so far as the Exhibit 3, which has been set aside by the High Court, and thereafter the direction was given to start if the opinion arises 145 questions. Then the 4 proceedings were started, and those proceedings were also dismissed on the ground that the matter pertains to the title. So it is essential that what was the nature of our possession, because in that particular case,
You see, if there is no evidence, no enough evidence to prove your possession.
no possession to my lord they are admitting. Even the court has also said that we are in possession of some of the
Where is that?
portion.
Some of the portions.
Maybe.
Certainly, some of
But it is not a case that we are not in possession. Even my lord, the appellate court has said that both the parties are not in possession.
which portion, which is that clinching evidence which will define your possession for the particular
Yes, in
property?
my humble submission.
Because you have not given proper boundaries to the properties.
My lord,
And your rent receipt also does not speak about any particular boundary.
rent receipts my lord does not my lord speaks. But hukumnama there is a boundary.
At least the rent receipt will tell that some plot number, or hukumnama must be giving some plot number.
Those are there. The both the courts of other impression that my lord, as because his hukumnama, which is admittedly a false one, has been created.
Admittedly forced.
Admittedly false.
They have admitted.
I am saying so. My lord. I am saying so because there is
That is not the question of law here.
my lord, that cannot be a question of law. Also. My lord,
Is there any finding that it is forged?
I will show it. Both the courts had said, my lord, it is not possible to decide that the hukumnama is actual.
So,
So that's why I am saying, my lord, they have intentionally, my lord, manufactured those hukumnama, my lord.
They cannot succeed
Then
on
I
my
am saying so. I am
weakness.
saying so.
They cannot succeed on my
I am saying
weakness.
so because
It may be my weakness. Let us presume that it is a forged document.
अच्छा एक बात बताइए.
आप अपना केस
वो
बताइए.
जो गुंडा जिन्होंने आपको रेंट रिसीट
गवाही करा है.
वो उसका गवाही हुआ.
हाँ हुआ है. एक तो इनका जो जमींदार थे उसकी गवाही उस प्रोसीडिंग में हुई थी.
किस
उसके आधार
proceeding?
वो 145 प्रोसीडिंग उसने हमें कहा.
नहीं उसका इसमें हुआ है.
आप तो कोनाई पर गए हैं. वो 144 और 144 हम ही पर कर दिए.
तो कनाइवेंस
तो उनके साथ अगर कनाइवेंस हो जाएगा तो हमारा
इसलिए बोलते हैं सरकार को जमींदार रखने में आपको बहुत फायदा है.
लेकिन इस पर्टिकुलर केस में वो दोनों ऑल दोज आर मटेरियल एविडेंस. एक बार कम से कम डिस्कस तो करते. एक भी डिस्कशन नहीं थी अपार्ट फ्रॉम ओरल एविडेंस में. जब हमारा ओरल एविडेंस में हम अपना पोजीशन
आप बताइए ना एक हुक्मनामा से रिलेटेड चौहद्दी बता दीजिए रिकॉर्ड से बता दीजिए आप.
प्लांट में है.
प्लेंट में नहीं आप उनको एविडेंस दिखाइए. क्योंकि आपका इन्होंने ये भी फाइंडिंग दिया है कि आपका डिफरेंट टाइम में हुक्मनामा हुआ. ठीक है.
बहुत टाइम
और
तीन बात है.
3 बार कैसे आपने 4-5 बार बताया. कैसे बोल रहे 3 बार. नॉट 3 बार.
160 का है.
1 2 3 4 5 हुक्मनामा है. ठीक है.
डेट बता.
हम देख लिए. हम तो सारा नोट किए हैं. 6/E तक है ना आपका हुक्मनामा. तो 5 हो गया सीधा सीधी. ठीक है. और भी बताइए. और दूसरी बात क्या है कि 5 हुक्मनामा 5 6/A to 6/E.
160 का है. ईयर में एक 60 का है. बहुत सा जब हुक्मनामा 60 का है. दो एक तो हुक्मनामा से
तो हुक्मनामा 60 का है. एक 61 का है. किसी में भी कोई कॉमन बाउंड्री नहीं है. किसी में भी बाउंड्री में आपका नाम नहीं.
ऐसा होता है. खतियान में चूंकि 2 ही बाउंड्री है.
हाँ तो वही एक बात बताइए. खतियान आपके हुक्मनामा से बनेगा कि हुक्मनामा खतियान से बनेगा.
खतियान हुक्मनामा से के बाद ना मिला है.
भाई खतियान में कुछ भी हो. लैंडलॉर्ड इज द ओनर ऑफ द प्रॉपर्टी.
इसलिए कह रहे थे गांव में
वो जब आपको हुक्मनामा से देगा तो खतियान में चेक करेगा 2 बाउंड्री है तो मतलब 2 ही बाउंड्री.
वैसा ही होता है. इसका कारण
ऐसा नहीं हो सकता.
इसका कारण बता दें.
ऐसा नहीं हो सकता है. कोई भी अगर खतियान में भी 2 बाउंड्री है किसी भी प्रॉपर्टी का, इट्स वेग. नो डिग्री कैन बी पास ऑन द बेसिस ऑफ दैट.
बहुत से लैंड कॉमन नेम से भी आइडेंटिफाइड हो सकते हैं. जब इसमें तीन नाम
ऐसा
टाइप नहीं हुआ
क्या
क्वांटी
हो
करा
सकता है,
क्वांटी
वैसा नहीं।
करा ये सब एरिया जो बोल रहे हैं उसके नाम से भी बाउंड्री आइडेंटिफाई हो सकता है, जो
नहीं।
कानून भी करता है। अब इसमें
नहीं, कानून कहने पहले तो
हम
आप
दिखा-
आप ही हमको बताइए ना कौन सा बाउंड्री है आपके पास।
हम इसमें कानून कर लेते हैं।
कुछ
कानून
नहीं
क्या
है।
करता है कि क्या प्रिंट में क्या डिस्क्रिप्शन है, लेट अस सी।
The property should be identifiable.
हम
चलिए सेकंड आप सुनते हैं, कंटिन्यू करेंगे। आप हमको सब प्रॉपर्टी का ना एविडेंस से बाउंड्री दिखा दीजिए।
I would like to place order 7 days.
Second.
I have a humble request if I can take the copy of the scanned copy of the documents.
It's always there.
From the
Where is your pen drive?
I will get a pen drive and I'll take
Get it right.
Much obliged.
That's fine.